আমি একটা জিনিস কালকে না আমি কালকে
May I have a my lord?
though today is not the mentioning, I'm not mentioning any matter for inclusion as a lordship.
Then
This-
what you are doing?
The matter was not there. Your lordship directed the matter to appear for forwarders after 2
That
weeks.
is not mentioned.
Not for inclusion.
Now you should have started like this, that I am praying for this indulgence.
Victory criteria,
My
well,
lord,
দিয়ে দেখে নাও কবে।
for 620
compelling
MNT number
circumstances, my
620
lord, mentioned one matter. One contempt matter is pending before the
চলছিল
single bench, my lord, and
supplementary
file is
ছিল,
not
যত
tracing, my lord. I
দুটো
noted later to the register of administration, my lord, but the file is not tracing, my lord.
Which file?
There's in 4 cans is there. One can number 4 of 2021
In
is
which
not.
matter?
There's one appeal, my lord.
no?
Also, kindly
Mention on Thursday. Come
we
tomorrow.
have a compelling circumstance. The contempt matter is pending before the single bench.
Have you preferred any appeal?
Yes, my lord. This order against these orders, my lord.
Again?
Against the order, single judge's order.
When was it made returnable?
That is very old matters, lordship, but lordship kindly accommodate us because we
Just on the day the contempt appears. you
are,
come and
last 1 month prior I mentioned it and lordship was liberty was given to matter will come, but we are not tracing his here and there because file is not tracing, my lord. Lordship kindly some accommodation is
দেখে নাও একটু। Yes, call the list.
grateful, my lord, grateful.
One, my lord, I am appearing on behalf of the respondent number 10, private respondent, my lord.
Who is for the appellant?
Lord, I am for the appellant, my lord.
Yes, Mr. Hotel.
Lord, can 3125 my lord of 2019, my lord. This is restoration, my lord. It has to be allowed for
Can
3125, my lord, of 2019.
that is not in the
That matter, that after restoration, you want to withdraw.
With the last occasion, my lord, your lordship was
I tell your lordship.
We are failed to understand on
Yes,
this.
yes. Kindly see, my lord. I'll
last occasion, your lordship was pleased to entirely direct my learned friend to call for record, my lord, from the BLR.
Achha, let us understand what he is saying.
Yes, my lord. If your lordship would kind enough to come to my lord, can 9, page 28. Can 9, page 28. My lord, it has been intimated to us that there was no proceedings under the, my lord, in 1994 by which vesting was allegedly done. May I place? In connection with the above, this is to inform you that that your appointed advocate Mr. Prangopal Das communicated the solemn order of the Honorable Division Bench arising out of can such and such on 20th May 2024 to this office, and later he applied for the certified copy of the order dated March 1, 1994 in case number such and such to this office on 7 June 2024. After thorough search in the office, neither any order dated March 1, 1994 nor any case file of such and such is found available in the office. Therefore, my lord, there was no vesting at all. There was no vesting at all. Now, my lord, I want, my lord, but this has been communicated to us. Now, my lord, therefore, my lord, this appeal, nothing remains to be, my grievances are not there. My grievances are not there. I want to withdraw the appeal. Lordship would kindly record that in view of this, my lord, the communication from the state, nothing survives in the appeal. Appeal has become infructuous.
We are yet to get our answer to our query.
Yes, my lord.
Why you want to get it restored and then withdraw?
Nothing survives. We want it to be recorded. That's all.
You have such service now.
This is not traceable. This is not. Nothing remains to be decided. You
My
are
lord,
for, you are for.
First of all, I am for the private respondent. My lord, private respondent has not been made a party in the instant application. First of all, No, my lord, has not been made a party. Thereafter, second thing, my lord, one of the respondent, added respondent number 9, my lord, expired during pendency of this appeal. No steps has been taken.
One,
Respondent number 9, my lord, said
Okay.
Shukur Ali.
yeah, we shall add another line that this proceeding has been abated in respect of respondent number 9.
No, thereafter, my lord, my humble submission.
Respondent number 9, only 7
No,
respondents.
my lord, added respondent. Subsequently, my lord, added. Subsequently, my lord, respondent number 9 and 10 was added on the basis
On the basis of which order?
of the order passed by my lord. Your lordship, kindly.
27th April 2017.
20. Then why did you make them party? যত গন্ডগোল করে
Milord,
My lord,
yes, this is Milord.
Yes, recalling application,
added respondent আছে
added
তো।
respondent.
In your recalling application, they are there.
No.
হ্যাঁ?
Can eight,
Can এইটা কি?
recalling
Recalling application.
Huh?
record.
They are there.
Respondent number
There.
9 and 10,
They are.
Yes, my lord.
They are.
9 died.
9 died.
This is a mistake in can
ঠিক
9.
আছে। লিবার্টি
Not
আপনি লিবার্টি দিয়ে তো 7 আর 8 হয়। এই
Do you add?
আমি তো বলে দাও so far as
Because Lordship would ignore that, because I'm saying that
How?
at my own risk, I'm saying that matter has become infractor.
No, no, Mr. Bhattacharya, we will give you leave.
Liberty to amend the cost type.
You amend just now. We will record his contention that the person has expired. It is a fact that you have not taken any steps.
Milord, no intimation was given.
No, so not. In fact, we will only record it stands abated so far as 7 is concerned.
9.
And we 9 is concerned, and we will restore the appeal. And we will make your submission that in view of that, you don't want to, you say that it has become infructuous and you do not want to proceed. with it.
Yes,
Ah.
yes.
My lord,
That's right.
my lord, my humble submission is that record has not been found. That does not mean that no proceeding was initiated.
After that is his submission.
head
We are
submission.
not-
Yes, my lord. My lord. If he may withdraw the appeal, I have no objection, but without any observation, my lord.
করছি না।
Yes, my
At my risk, I am doing so.
Leave টা
তো জন্য ওইটা লিখে দিলাম তো।
Mr. Bhattacharya, learned advocate, as
Number 2, my lord. Mr. Santimoy Bhattacharya appearing for the petitioner, my lord. Earlier, last occasion, my lord, your lordship adjourned the matter on the ground that the learned senior advocate, Mr. Supratim Dhar, no junior was engaged. On that ground, only the matter was adjourned last
I
occasion.
tell you, Lordship, this relates to a Borgadar matter. 22, we have used affidavit in opposition, they have used reply towards their writ petition, and then matter got dismissed for default in the year 2023. So, my lord, I do not have the brief writ petition
2023,
2023,
and it is a LRT of 2013.
my lord.
My lord, restoration application filed
Now
within
they have
time, my
come up with the restoration application, my lord. They need to serve restoration application along with all the papers.
Read petition.
Yes, otherwise how he will appeal?
Then we shall serve.
No. First serve, then rest.
Yes, sir. I shall serve.
Give it to him. You don't have.
In course of today, I shall, after Xerox it, I shall serve.
দেখি ফাইলটা দাও।
ওনাকেই করে দেবো।
আছে, আমি নিতে পারবো।
Mr.
Restoration application was filed within time.
Yes, my lord.
Not
I don't know.
14ই আগস্ট
Oh, that's 2 days.
না উইদিন, হ্যাঁ 12ই সেপ্টেম্বর ফাইল করেছে, ঠিক আছে,
Within time, my lord.
Yes, yes.
Oh.
উইদিন টাইম। না, হু ইজ ইয়ার অন রেকর্ড মিস্টার?
Well, nobody, because that time, during that time, my lord, I was appearing on my own.
To we engage, yes, Mr.
Lord.
Gupta, you are state.
My lord,
Oh, you, who is in government?
No, sir, I'm not in
Acha,
state.
you are
my
in
lord,
government.
she is in state panel.
She is in government.
Yes.
Engage করিয়ে দাও, restoration টা allow। এই নাও, নিয়ে নাও। ওটা রেকর্ড করে দেবে, সম্মুখে সার্চ করবে ইন কোর্স অফ দিস। I cannot.
নাম
আমি দিয়ে দিচ্ছি। তন্নিশ্রী মুখার্জি।
You have served this, any private respondent is there?
Yes, my lord.
You have served,
Yes, negative service.
where is your service? আরে সব বলে বলে
Earlier
বের
of-
করতে হবে নাকি?
বার করে দাও।
Earlier occasion, negative service was.
আবার বলে earlier occasion. How many private respondents are there?
জিটটা বার করো না।
6, 7, 8, 9, 10, 11.
whether they are substituted in main petition.
Yes, my lord, all served.
Why?
They were substituted.
Yes, my lord. Substitution application was filed, that has been allowed.
When it was allowed?
Yes.
What is it? You have served. You have served them.
Yes, my lord.
Checked up.
Yes, my lord. Delivery confirmed.
নিয়ে নাও তো।
As a dispatch service.
No, this is my copy, my lord. My lord,
Original
earlier,
copy কোথায়?
earlier occasion, my lord.
ও বলে earlier occasion দিয়েছে। কোনো earlier occasion কপি?
এটা নিয়ে দেখ।
Or where is the original copy?
Original, earlier occasion, it was, my lord, kept with the record. Told me.
If it was kept on record, we would have passed an order. When did they receive the service?
My lord, 26th September 2023.
তখন তো আমাদের determination ছিল।
Then, my lord,
Serve and come.
I shall serve, my lord.
Serve and come. Petitioner prays for complete service.
May I serve only the application for restoration application or the copy of the writ petition also?
That if you have served, it's okay, but you serve the entire setup on him.
Since they have been substituted, you should have served
Right.
a copy of the main petition also.
Read petition, opposition as well as reply.
Yes.
নতুন লোক চলে এসছে তো সাবস্টিটিউটেড লোকদের উপরে করতে
কত
হবে না তোমার
খরচা করবে না ডিসমিস করে দেবো?
আচ্ছা সাহেব নয়
খরচা করবো, বলুন তো।
আচ্ছা,
সার্ভিসের একটা অর্ডার
আচ্ছা, Mr. Satansan Lanet Advocate.
তিন নম্বরটা আছে একই
14 সালের আমার এফিডেভিট
না না 3 নম্বরটা আছে
হুম।
একই নয়
মানে সেম ম্যাটার
আইডেন্টিক্যাল ম্যাটার
সেম অর্ডার। 2 weeks না, ওটা 3 weeks সেন্স কমপ্লিট হবে না সার্ভিস। ইয়েস, নেক্সট।
My instructorship, the interim order is going to expire on 28th.
Interim order against you? Interim order, you are for the,
Petition election.
oh, petition.
Yeah, appellate.
And on the last occasion, your lordships are kind enough to direct me to file affidavit in reply
হ্যাঁ হ্যাঁ,
in respect of the affidavit in opposition filed by my learned friend to the stay
Mr.
application.
De Lanet, Mr. De La, senior government, you're senior, no? Mr. De Lanet, senior advocate appearing for the appellant What was the interim order, Mr. De?
Lordship,
What was the interim?
Impugned order.
impugn order.
Benefit of promotional post.
Yes, after retirement and all these things. I'm deeply wounded.
I am for the, my lord,
I
lead
appear for the
petitioner
petitioner,
before
my
the applicant before the tribunal.
Applicant.
Yes, original applicant before the tribunal.
You are for the petitioner.
Petitioner.
I am the original applicant before the tribunal.
No, my lord, I am the private respondent before the tribunal. At my instance, it has been dismissed.
This is my application filed assailing an order whereby my application under section 5 praying for condonation of delay has been rejected by the honorable tribunal. Lordship kindly comes to the impugned order first.
How many days delay?
164 as per the application. My humble submission, the impugned order, the findings are absolutely perverse. May I just place the order if Lordship permits?
Yes.
May I, my lord?
Yes.
It is an application for condonation of delay under Section 5 of the Limitation Act, by which the applicant has submitted that he appointed his father as his constituted attorney who had been suffering from various ailments, including suspected COVID. Moreover, this applicant came to know about the order on 27th of July 2022. That is when I'm pleading my knowledge. When the private respondents disclosed the order before the civil court, although the order was passed by the appellate court on 29th of March 2022. By filing the supplementary affidavit, this applicant submitted medical certificates of Dr. Taposh Sarkar and Dr. Indranil Molli.
Which order you are reading?
My lord, the impugned order kindly comes to the impugned order dated 17th of January 2025. There are two orders impugned. That second order, my lord, 17th January.
Just.
Yes.
I'm all right. That is the difficult problem.
So your father was sick from 14 July to 29 July.
No, my lord. My father was sick from 14 July to 26th of October 2022. There's a
Why?
typographical error. The medical certificates that I have annexed, from there it will reveal, lordship, that it was still October. May I just place
This was
my case?
till October.
Till October, lordship. There's a typo.
Tribunal took it as July.
As July, and moreover, lordship, tribunal has
No,
perversely.
tribunal say next from 27 July to 26th October.
Yes, lordship. It should have been October because the
It has been
certificates.
accepted.
Yes.
Now when was it? When did you file the application?
In November 2022. May I just place the facts briefly, my
No,
lord?
just let
Yes,
us understand.
lordship.
November 2022.
22. 10th November 2022, I filed the original application.
And your sickness was till 26th October 2022.
22. Yes, my lord.
And what about this disclosure of appellate authority order?
Yes, lordship. The appellate authority without hearing me, without granting me an opportunity of being heard, has passed an order whereby my name has been deleted from the record of right.
You were not given.
I was not given notice, I was not made a party. May I just, and that is the reason, that is what I've pleaded in my section 5 application.
What did you challenge before? He was the original applicant before the tribunal.
No.
Not
No,
you.
I am the original
What did you
applicant.
challenge?
I challenged an order passed under section 54 by the appellate authority, whereby my name has been removed from the record of right without granting me any opportunity of hearing. My specific case in my section 5 was that I had no knowledge of the order that I was assailing. The order whereby my name was removed was passed in March 2022, my lord. Kindly comes to that order starts at page 39, and the operative part, lordship, is at page 44. Kindly comes to page 44 at the bottom. May I just
So
read
when
out,
you filed the original application,
lordship?
the statutory appeal had already been disposed of, because it was disposed of on 29th of March 22.
29th of March, yes, the appellate authority passed its order. Yes, my lord.
Now you filed the original application
Yes.
in August 2022.
My instruction, lordship, it was
Page
in
70.
17. Yes, lordship, it is written August.
It is written August. Now, what was your prayer? You challenged an order of 29th March.
Yes, lordship.
That is the order of the appellate authority.
Yes, lordship.
Then why you are saying you had no knowledge that any such order was passed?
Because I was not made party before the appellate authority. I had no knowledge that on March 2022, an order was passed against me whereby my name was removed from the record of right.
But you have challenged that order.
Yes, lordship. I
Got
came
the
to
copy of the order.
no, I came to learn about it when the private respondents in a parallel proceeding before a civil court in a title suit disclosed the fact that such order was passed, and I came to learn about it in July 2022.
And thereafter filed the
I have
original.
filed the original application in November
Which
because of my,
paragraph of your original application you have stated that?
my lord, I have taken out a section 5 application. Kindly comes to page 75.
75.
5. The pleadings start from page 76. Kindly sees paragraph 1 and 2. That inter alia challenging the order dated 29th March passed by the appellate authority, the instant application has been filed. That the applicant is a government employee and residing outside the state of West Bengal, and accordingly could not collect all documents immediately after passing of the impugned order. Moreover, he came to know about the order on 27 July 2022 when the private respondent disclosed the order before the civil court. That is my specific case here, that I had no knowledge of the order, my lord. I came to learn about it on 27 July 2022. Interestingly enough, the private respondent, not the state, have filed any written objection. They have not been able to make out dispute or deny this particular contention of mine. If your lordship will again peruse the impugned order, it states their oral objection has been recorded. Simply they have stated that they are not satisfied with the explanation that I have given, but they have not disputed my date of knowledge.
But where is the fact of your ailment you have stated?
Yes, lordship. I
That
have filed a
actually-
supplementary affidavit. Kindly comes to page 79, whereby I have disclosed the particular medical documents. Kindly comes to page 79. This is a supplementary affidavit to the application under section 5 of the Limitation Act. Kindly comes to page 81 and 82. These are the medical documents that I produced before the Honorable Tribunal.
So had you been sick up to October 22, how
Lordship.
could you file the application in August 22?
My lord, it is written August, but my specific instruction is it was filed in November 2022.
এই রে, সেটা কি করে বুঝবো? Your affirmation sheet says it is August.
Yes, lordship, but it was filed in October, my lord, in November, my lord.
Who affirmed it before the tribunal? Your father.
My father affirmed. He is my constituted attorney. He affirmed. Now, lordship will see the impugned order.
Now the appellate authority has removed your name from the record.
Yes, he's removed the name of my vendor's vendor and saying that because his name is removed, consequently my name has to be removed. So principle of natural justice took a nosedive.
Mr. Lahiri, don't oppose.
Yes, my lord. Only paragraph 3.
আর only paragraph দেখতে হবে না।
Well, the tribunal is, my lord, passing similar orders. Lakshmi, kindly clarify in other matters, tribunal may not take such a stand.
We are passing order in this matter, not other matter.
Well, one, this order
Vehemently opposes.
vehemently of
নিয়ে নাও।
paragraph 13, my lord, kindly considers, my lord, if your lordship, this will be, my lord, inuring to the benefit of the others also in the tribunal. Only this order is being clarified and cited and everything is being, my lord, dismissed. In other matters also, we are suffering this kind of orders. If your lordship kindly, my lord, takes note of paragraph 13 of this judgment which has been quoted and clarifies that in all matters this should not be applied. There should be, my lord, difference in facts and circumstances. That judgment which has been quoted in the order kindly says that if your lordship kindly, my lord, it pleases that it should not be applied, my lord, in all the matters. In that matter, there was a delay of 5 years. And my lord, the tribunal is relying on paragraph 13 to dismiss all the original applications. Kindly seize paragraph 13.
Copy দেবেন স্যার।
ওই জাজমেন্টে যেটা দিয়েছে
তো report
অনলাইনে
এ
রিপোর্টের এনে এনে নিজেই ডিস্টিংগুইশ করে দিচ্ছি তো, ডোন্ট ওয়ারি। This judgment is being quoted in every matter, my lord.
There the delay was how much?
5 years.
Where do we find that?
It's there, my lord.
There's a delay of 6 years, my lord. Just
6 years and 5 years there.
para 13,
1200 days.
1200, para 13, just line before para 13, my lord.
6 years.
Same page.
Para 12 one.
This is being relied upon to, my lord, dismiss all.
The present writ petition. তুমি বলছো? দাও তুমি দেখো। You know,
And vehemently opposed.
power infinity.
What, my lord, the Wakalatnama is in demi paper, kindly gives me leave to, my lord, file. But this is in this paper, department will not take. Kindly gives me leave.
Challenging the order
my learned senior friend. So
Everything fine? Yes, next.
I'm appealing for respondent numbers 4 to 9, Milord. Milord, I will be humbly, Milord, seeking 1 week's time, Milord, to file. Milord, the opposition is almost ready, Milord. It is an old record, Milord. Milord, if your lordship kindly grant me, Milord, time for 1 week, Milord, I will file my opposition as your lordships were directed, Milord, in the earlier occasion, Milord. Milord, may I just file my opposition, Milord?
File it, it will appear on 10th then.
Milord, I will serve an advance copy, Milord.
কি দেখি একটু দাও। Mr. Chakraborty, learned advocate, appearing for the respondent numbers 4 to 9. Res-
May I please your lordship? My lord, this is my application for stay. My lord, in fact, my lord, there is no scope to pass any order of stay. Your lordship to hear the appeal on merits. My only prayer is, my lord, an order of compulsory retirement has been passed in 2016. Till date, my lord.
2009.
Yeah,
2009.
2009, compulsory retirement. The matter is pending before this honorable court. My lord, till date, he has not been paid any retirement benefits. My only prayer before your
But
lordship,
everything has been
as a-
paid. I have the copy of the division bench order. Well, Malayan print doesn't know
No,
all the facts.
my
But
instruction
I
is-
have the copy of the order with me.
No, no, Mr. Nyogi, which order you are challenging?
Impugn order dated, my lord. My lord, it is
25th
on.
September.
Yes, my lord.
So in that you challenged an order of compulsory retirement.
Compulsory retirement, my lord.
Now the
And
writ-
also appellate order. Also
and
the,
appellate
yes,
order.
my lord.
Now the writ court has dismissed the writ.
My lord. Your lordship was to hear the appeal on merit, my lord.
File your paper books.
Malad, in the
Ashwin?
paperwork, Malad, in the state petition, Malad, no documents have been annexed. Malad, the
You
relevant
need it.
relevant documents may be annexed, Malad. You'll say, kindly give.
No, you have exchanged affidavits, no?
No. I have not. This has been served just, Malad.
No, in the
Before
writ
the-
petition.
Yes,
The writ petition, Malad. In the writ petition, there are several writ petitions. In one writ petition, they have made one prayer. In another writ petition, with another prayer. Malad, with regard to the prayer for payment, everything has been passed.
No, we are not on that. We are wanting to know, did you file your opposition in the writ petition?
yes,
The
yes,
writ petition, my lord, in the writ petition, my lord, in this matter, I was not there. There are two matters. One in 2008 matter, one in 2013 matter. 2008 and 13 has been taken together, and the order has been passed. Not the in 13, I was not there. But if whatever may be the records, all the documents may be annexed.
Oh, two writ petitions were.
Were taken up together, and my lord, it was disposed of. You'll also kindly see.
What is the other writ petition about? One was challenging the order of compulsory
my lord,
retirement.
two appeals have been filed. Records are before your lordship.
Yes.
Well, only one state petition has
We
been
are
served.
required to file two appeals. Maybe
My
court
lord,
has
in a
passed-
composite application, my lord, stay application has been filed.
Composite na. Composite na.
Already-
Composite to
A
correct
stay application has been filed with regard to one appeal, my lord.
one appeal.
One appeal.
Whether you have filed one appeal or two appeals.
Two appeals.
Yes,
That is the
In
other
one
one.
appeal, my lord, we have filed application for stay.
in another appeal, or what is another appeal?
That has been mentioned before your lordship. That has not been this stay.
Oh,
But
that
that
is not-
copy has not been served.
application
application করিনি তো
করেননি তাহলে মেনশন কি করে করলেন?
এইটাতে অ্যাপ্লিকেশন করতে
You, there is a procedure. You file a formal application, give a copy to him, we will direct that matter to be listed.
Yes, my lord, that's the reason. That's the requirement.
At a 2-page application, you file appropriate order. Then we will dispose of everything, direct you to file paper books and hear it.
Malo.
Got it?
As a lord.
We are not recording a formal order to that effect. Give the number of the other appeal.
Malo.
You give the number to our court officer and both the appeals will appear 2 weeks hence. In the meantime, you serve an application upon him.
As your lordship.
2 weeks hence করে দাও আছে কত তারিখ আজকে 22 তারিখ
Malo, in the meantime, we will file paper for in paper book. Malo.
হবে
let that we will combine the two appeals and will
Yes.
direct you to file one paper book,
Malo.
composite paper book with all annexed.
Malo. I will file. 4 weeks time, I can begin. 4 weeks time.
No, we will pass that
Yes.
order after that appeal comes up in the list. That is
Mal-
not in the list.
All right. I'm grateful.
Can you file the application within a week?
Yes, ma'am.
হ্যাঁ তাহলে ঠিক আছে ওকে আজকে
Your lordship, kindly give a direction, otherwise my lord again we should kindly give a direction in this matter. my lord.
What direction?
To file application. Oral direction we can.
As your lordship.
11 তারিখ রেখে দাও 11th March.
11th March.
Number দিয়ে দাও।
Give the appeal number, give the other appeal number.
Yes, ma'am.
Eleventh March.
ঠিক আছে।
নিয়ে নিয়েছো কার্তিক
Yes, ma'am.
আরেকটা অ্যাপিলের নাম্বার
Yes, ma'am. 11th March. কষ্ট হবে না
এটা কোনটা?
এগুলো দাদা কোনটা এগুলো কিসের ওই সব ফিরে এসছে নাকি
এর মধ্যে দেওয়া ছিল উইথ বলে
এটা।
এভিডেভিট অফ
আচ্ছা একটা অর্ডার লিখে নাও রেকর্ডস রিভিউ
Evidence service.
একটু আমার এভিডেভিট অফ সার্ভিস অ্যাজ ফাইল বি কেপ্ট অন রেকর্ড
It's my appeal, my lord, that there is a delay of 78 days to which they have used an opposition to my section 5 application. No, sorry, sir. Delay to what? 78. I'm sorry, my lord, 300 days. Sorry. এটা কি দিলি? Reply. এটা opposition. But my lord, neither any third-party rights have been created because of the delay, my lord. Nor, my lord, they have changed their position to the extent that the delay cannot be condoned. But we have tried to
Section 5.
section 5, my lord.
Manual.
But may I file the reply to the section?
Where is the explain?
My lord, my lord, will kindly take from paragraph 24 onwards.
No, what happened on that day before the contempt court?
My lord, the honorable single judge had been taken to pleased to take up the matter twice. My lord, first day the honorable single judge directed us to make a calculation of the dues of the petitioners in terms of his lordship's order. And on the next day, my lord, directed us to deposit the amount. My lord, we have deposited the amount. And my lord, the contempt was adjourned. The contempt is appearing today because, my lord, this matter was returnable before lordship on 10th of February. My lord, since this bench was not available, we mentioned the matter before the relevant bench, my lord, on 11th February, when the honorable court directed us that you wait for the bench to return to be available, you move before the bench and make a request before the honorable single judge, where the honorable single judge should know that this bench is not available. However, my lord, the contempt matter, when the bench was not available, the matter did not appear before the contempt court.
No, there was a personal appearance. Na?
Personal appearance was, my lord, we had carried out that order, my lord. The principal secretary, my lord, was present along with the other contemners before the court on 2 occasions, my lord, one physically and one virtually.
What is the main matter about?
My lord, the main matter is with regard to parity between Ayush doctors and allopathy doctors. Now, my lord, they say that they are on the same pedestal and accordingly similar benefits to be given to them. Now, my lord, there's if I place the impugned order, my lord, your lordships will find that the impugned order is relying upon a decision of 2021 volume 17 SCC 642. My lord, that your lordships will find petitioners are Ayush doctors, my lord. They are having the lesser pay. Now, my lord, if your lordship kindly in the impugned order kindly takes, my lord, the internal page 10 or in the stay application page 469, either of the two, my lord, that will be paragraph 34 of the impugned order. I'll place the entirety of it. I'll just giving a short reasons, my lord, for seeking a stay today. My lord has got 34, my lord. Your lordship will find that there is a reliance on North Delhi Municipal Corporation versus Dr. Ram Naresh Sharma. There's a quotation is there. Then kindly comes to paragraph 36. Also, there's a reference to Allahabad High Court decision of Ram Suresh Rai. But in Ram Suresh Rai, this North Delhi municipality is referred to and relied on in paragraph 23. But when required, I'll place it, my lord. Then your lordship will kindly take paragraph 37, where a Manipur High Court decision is relied upon. Paragraph 37. And thereafter, at paragraph 38, a Jharkhand High Court decision of Jyotish Chandra Singh is relied upon. Now, my lord, in that paragraph 38, kindly, my lord, comes to the second sentence once. In the backdrop of the above, my lord, I am reading, my lord, from paragraph 38. In the backdrop of the above, uniform dicta being followed across the country, and particularly of the observations of the Honorable Supreme Court in the case of North Delhi Municipal Corporation, this court is of the clear and unequivocal view that the Ayush doctors must be paid the same remuneration and wages benefits including the date of retirement at par with the allopathic MBBS doctors engaged in the implementation of any scheme of the state or the central. The principal secretary will do so and so. These are the directive portions. Therefore, my lord, the entire basis of this decision is North Delhi municipality. Now, my lord, these other high courts which has been relied upon to be said that there's a parity of decisions are also based on that North Delhi municipality. But my lord, subsequently, 2 years later, that judgment has been distinguished and clarified. But I'll place that, my lord, that is, my lord, in my stay, my lord, that is the only pertinent point, my lord.
So that you didn't say, tell to the learned single judge.
That was not pointed out before the honorable single judge. একবার দে ওটা আমাকে 2023 ভলিউম 15 টা দে
নাম্বার 1 একটা বার করে
আর আমার কাছে থেকে but kindly takes this মানে will make the position absolutely clear man
কপি দেবে কোনটা
2023 ভলিউম 15 SCC 257 রিপোর্টেড জাজমেন্ট তো কপি আনিনি ওই জন্য লাগলে দিয়ে দেবো 2023 ভলিউম 15 SCC কি আমার কাছে কপি আছে আমার তো সফট কপি আছে হ্যাঁ ভলিউম 15 2023 ভলিউম 15 SCC 257 1819
Now, what have, pursuant to the order, what have you deposited?
Malad, the entire area calculation of the petitioners up to December 2024.
December 2024. That you told the learned single judge.
But that was the direction of the honorable single judge. Malad, matter appeared
In the
before,
contempt.
appeared before Lordship. Malad, my learned friend took a point that the section 5 is to be decided. Your Lordship directed the pleadings to be completed, matter placed on 10 February. That day itself, Malad, the personal appearance was there. We appeared before the honorable single judge. The alleged contemners were present personally. The court directed us that you make a calculation and deposit the amount. If you deposit the amount, the contemners may remain present virtually. If not, they should be present physically. In the meantime, Malad, we got 2 working days, a Monday and a Tuesday. We deposited the amount with the learned registrar. The amount is now deposited with the learned registrar. We appraised the same to the honorable single judge, and the matter has been kept today at 2 p.m.
My lord, according to the prayer of my learned friend, that we have prayed for deposition of amount. For this reason, direction was given. Apart from that, kindly see in the affidavit what they have stated before the learned court below. They have specifically stated that they will comply, paragraph 14, my lord.
That is immaterial.
They will comply the order.
But compliance does not make the appeal not maintainable.
For this reason, my lord, that
I am saying that the order is wrong in law.
was adjourned.
Order is wrong in law. What I
My lord,
what
the
I am
highest
doing is contempt
principal
is material.
secretary of health and my lord, the principal secretary health education, both the contempt number 1 and 2 filed this affidavit. 2 affidavits, my lord.
Yes.
In
Which
both
paragraph you are reading?
paragraph Roman 14, my lord. At page, my lord, 13 and 14, my lord. The respondent number 2, that is at page 13, my lord, and respondent content number 1, page 13, my lord.
Yes, what they have said that they are paying the money.
No, my lord, kindly see that paragraph 14, your lordship got it right.
Yes, that it is necessary.
That I am also praying before the honorable court to grant me 4 weeks time, more time, for comply the order of the honorable court unless I shall suffer irreparable loss and injury. So that was the prayer.
No, that means here their right
Order
to
to
appeal has waived.
So, my lord, when they have, my lord,
They are saying that the entire judgment has been passed based on a decision rendered in 2020.
no, my lord, that is
That
not.
judgment has clarified by a subsequent
That is not,
judgment of
my lord, that is not
2024.
correct. That is
And
not.
the judgment impugned. Problem is that you will not. Judgment impugned was passed in January 2024.
Yes, my lord.
That means after the
Near about 300 days.
After the 23 judgment, that judgment has not been brought to the notice of the learned tribunal.
My lord, that,
So that point should be decided or not.
my lord, before that, my lord, regarding
Third line has been written.
that was written by the respondent content number 1 and 2 in both the affidavits. And my lord, it is not that implementation of the judgment of the Honorable Supreme Court, implementation of the, my lord, the policy of the central government. 5 direction was given by the central government, Ayush Ministry to the state government. My lord, it is not that, my lord, that all the allopathic doctors, we are claiming the ACPR with the all allopathic doctors. No, my lord. Our claim is restricted who are engaged in under the National Health Scheme. Although, my lord, it is on merit. My lord, now your lordship is taking the section 5 application.
But if your lordship sees that 2023 judgment, what my learned friend is saying, exactly that is clarified in paragraph 18 and 19. This 2023 judgment that I have handed over, my lord.
Central government has already released that money.
My lord, with the deepest of respect, my lord, what my learned friend is arguing are points in contempt.
Paragraph
18 and 19. Kindly takes 18. A cursory reading of the portion of the judgment in Ram Naresh Sharma. My lord, this is the North Delhi municipality judgment. Extracted supra may give an impression as though the question arising for consideration is no longer res integra and the allopathy doctors and the Ayurveda doctors should be treated on a par insofar as all service conditions are concerned. But a careful reading of the entire judgment shows that the said decision was based upon an order of the Ministry of Ayurveda, Yoga, Naturopathy, Unani, Siddha, Homeopathy, dated so and so. As seen from para 2 of the said decision, the age of retirement of allopathy doctors was increased by an order dated 31st May 2016 issued by the Ministry of Health and Family Welfare. This was followed by consequential amendment of the fundamental rules and supplementary rules of so and so. Since Ayurveda doctors were not covered by the ministry's order dated so and so, Ayurveda doctors filed application before the administrative tribunal. The administrative tribunal allowed the application by an order dated so and so. The North Delhi Municipal Corporation employer filed writ petitions before the High Court of Delhi challenging the decision of the tribunal. During pendency of the writ petition, the Ministry of Ayush issued an order dated so and so enhancing the age of retirement of Ayush doctors also to 65, but with effect from 27 September 2017. It is in that context that this court held as aforesaid in Ram Naresh Sharma. This court did not go into the question whether Ayush doctors and allopathy doctors were performing equal duties and responsibilities so as to be entitled to equal pay. We must remember that the fundamental distinction between the issue of law, that equal work entails equal pay, and the issue of fact, that as to whether two categories of employees are performing equal work or not. This court did not go into the factual aspect in Ram Naresh Sharma as to whether Ayush doctors were performing equal work as allopathy doctors. This court simply relied upon the order of the Ministry of Ayush itself, enhancing the age of retirement of Ayush doctors on a par with allopathy doctors. Similarly, this Ram Naresh Sharma could not have been relied on the basis of the Honorable Single Judge's order. This parity of law which the Honorable Single Judge has held in the order, relying on Manipur, Jharkhand, and Malad Allahabad High Court, those orders are also Malad without taking into consideration, because when Jharkhand, Manipur, and Allahabad was passed, this order did not come. So this position of law has also not been considered by Allahabad, Manipur, and Jharkhand. And your lordship will see when I place the entirety of it, I was trying to summarize my point today, that this factual aspect, that is Roman 2 in paragraph 19, has also not been considered. But this point of law kindly decides. Explain my delay, my lord, in paragraphs 24 to 28.
Delay is how much?
300 days.
Now the delay
But
is,
that is also not stated in the petition also.
Mr. Ghosh, we will have to decide the appeal, na? Now, as you have rightly pointed out that they have said we will comply with the order. But when a point is being raised, we have to return our
Yes, definitely.
finding on that.
But my lord, my submission regarding that judgment, what my learned friend is submitted, that is, my lord, in respect of as a whole allopathic doctor and Ayush doctor. My lord, my case,
Hear you certainly. If we hold in your favor, naturally the order goes. If he fails to say that this is an proper explanation of the earlier judgment, we will dismiss the appeal. But if the contempt proceeds and the appeal is pending before us, it becomes an anomalous situation. We will, appeal becomes infructuous. No? Now, are you seriously opposing the delay application?
yes, my lord, for this reason, my lord, I am filed the affidavit in opposition.
Yes.
And your lordship was also pleased to direct on last occasion.
All right, to place your section 5.
Opposition. Well, kindly takes my lord paragraph 24 onwards, my lord, page 20. The delay in preferring the instant appeal, which has been inadvertently caused due to impersonal
You
machinery.
have quoted the Supreme Court observations in that order. That has been quoted.
But my lord, but that is why I was not placing it. But my lord, your lordship is aware, my lord, of the Esha Bhattacharya judgment, my lord. My learned friend's main issue, my lord, to be considered by your lordship, my lord, irrespective of what I say, what I write, that whether any third party right has been created in the meantime or not, number one. Number two, whether he has altered his position in a way, thinking that no appeal will be preferred, so that it is an irreversible situation today. But they are still in employment, they are still getting the salary. The area today, in terms of the honorable single judge order, has been deposited today. So that amount is secured.
Where is your opposition, Mr. Ghosh?
My lord,
Yes, tell us, Mr. Ghosh, what is your...
my lord, kindly see that page of section 5 application, page 20, my lord.
এশাটা আনতে বলেছিল রাহুলকে দেখো এশাটা
Page 20.
Page 20, my lord, just now what my learned friend shows, my lord, the paragraph 23, 24, my lord, only stated a delay about this. Page 20, my lord.
Your
No, application.
application. Huh. Oh, you are showing their application.
Yes, yes.
Page 20.
Page 20.
Yes. Paragraph 24.
23, 24 and onwards, my lord.
Hmm.
26, those are, my lord, the explanation of delay.
Hmm.
My lord, that is not at all, not a single statement was made. Why the delay was made?
Paragraph 24.
23, 24, those are, my lord, not at, my lord, what was the reason behind the delay? Not a single sentence. Only, my lord, that bureaucratics delay, that was the main thing. And my lord, in what manner that was drafted, kindly see the page 21. Last sentence of paragraph 26, they have explained the delay of review. Most unfortunate thing, my lord. Last sentence, may I read, my lord? In the instant case, the said the unintentional delay was caused as the same procedure had to be followed and the review application was only preferred after the learned legal remembrance appointed state advocate for the filing of the instant application. I don't know, my lord.
No, that's a typographical error, my lord. I agree.
Anyhow, my lord, that such a serious matter.
No, my lord, it's supposed to be read as, my lord, stay application. That's a typographical error.
But the K draft for you.
My lord, it has slipped my notice, my lord, while settling it, my lord. My fault, my lord.
And my lord, thereafter, paragraph 28, and my lord, no statement regarding the delay. And my lord, not even stated that how many days delay was there. At least in my petition, I have not found out. My lord, kindly see the prayer also, my lord. About days. My lord, what was the days, my lord? In the petition, my lord, I have not seen.
The present appeal.
My lord, may I show, my lord, two judgment, my lord?
বস-
Jayaram Bhagiria.
Citation.
Yes, Jahangir Bomboji versus এটাও রিপোর্টেড জাজমেন্ট।
সাইটেশনটা দিলেই তো বোঝা যাবে রিপোর্টেড কিনা।
পাচ্ছি না আমি, দিয়ে দেবো।
তাহলে তো কপি দাও।
My lord, that kindly come to the paragraph 31, 33 and 34, my lord.
তো এখানে সেটা কোড করা আছে।
Paragraph
সেটা কোড করা আছে, যেটা দেখাতে যাচ্ছে না এখানে কোড করা আছে। অনুরুদ্ধ বস্তু না পার্টিওয়ালা। 27 থেকে অ্যাপ্লিকেশন।
Yes, Mr.
My lord, kindly see the paragraph 31.
31.
The Esha Bhattacharya, which I was trying to cite, Malad, is luckily quoted here,
In the case of Lanka Venkateswala, Andhra Pradesh, reported in 2011, 4 SCC 363,
31,
this could made the...
Just a moment.
Yes, ma'am.
Paragraph 31.
Paragraph 31, my lord. Page 18, my lord.
Page 18.
18, my lord.
Oh, yes.
My lord, that the court made the following observation. In N.K. Balakrishnan, such and such, this court again reiterated the principle that rule of the limitation are not meant to destroy the right of the parties. They are meant to see that the parties do not restore the dilatory tactics, but seeks their remedy promptly. We are at loss of fathom any logic or rationale which could have impelled the High Court to condone the delay after holding the same to be unjustifiable. The concept of such as liberal approach, justice-oriented approach, substantial justice cannot be employed to jettison the substantial law of limitation, especially.
But there was a delay of 12 years. 12 and a half years delay in this matter.
And my lord, another judgment, my lord. And my lord, ultimately.
আবার কতগুলো জাজমেন্ট? শুধু পরিশ্রম দাও তো।
And my lord, no explanation is there, my lord. And I want to show only one statement from my opposition, my lord.
পয়েন্টটা কি দিলে সাইটেশনটা দাও।
My lord, that is my lord, paragraph 27, 28 and 29, my lord. That is the last page, my lord. Despite the writ petition having been filed, my lord, last page, paragraph 27, 28 and 29.
27, 28, 20. হ্যাঁ, কি বলছো?
My lord, despite the writ petition having been filed belatedly in respect of the certain action which had commenced in the year 2005, and even though the writ petition was filed after obtaining approval of the Executive Council, no steps were taken to file the writ appeal for 916 days for disposal of the writ petition. In the circumstances, the cumulative effect of the delay as laches cannot be ignored. The decision referred to the learned senior counsel for the appellant noted supra cannot thereof be applied in the present facts and the circumstances in as much as the consideration hereunder was not merely the explanation of the delay of few days in filing the appeal, though the contention in put forth that the delay is required to be condoned since public interest is involved. The nature of the proceedings that have taken place thus far would indicate that the matter has been examined at different stage in the earlier litigation, and if the grounds on which the appellants was assailing the action of the respondent were to be examined on merits, there ought to have been more diligent in prosecuting the matters before the court. In the matter of condonation of delay and laches, the well accepted position is also that the acquired right of the opposition party cannot be lightly dealt with. In that regard, rather than the taking note of the hardship that would be caused to the respondent number 13 as contended by the learned senior counsel, what is the necessary to be taken note in the manner in which the respondent number 11 DMRC has proceeded in the matter. The respondent number 11 DMRC is engaged in providing the public transport, and for the said purpose the government through the policy decision has granted approval to the generate resources to the property development, and in that regard the development as earlier indicated is taken up. Pursuant thereto, the respondent number 1 has received a sum of rupees such and such from the respondent number 13 as far back in the year 2008. The said amount as indicated is used for its project providing metro rail service to the communicative public. In such circumstances is at that stage inordinate delay in condone ultimately unmindful for Lancastrian manner in which the appellant has proceeded in the manner it would also be contrary to public interest. Therefore, taking into the consideration all this aspect of the matter, we are of the opinion that not only the learned single judge was justified in holding that the writ petition inter alia in hit by the delay and laches, but the decision of the division bench in dismissing the PLA on the ground of delay is also justified, and the order do not call for interference. And my lord, they have to, my lord, apart from the whatever may be the date of delay, my lord, I am not on that. My lord, they have to explain properly and they have to give some reason. My lord, what is the only, my lord, their reason is, my lord, that the bureaucratic policy. My lord, that cannot be the only, my lord, the delay reason for the condemnation of delay. And my lord, more surprising thing, my lord, the central government, I don't know whether the central government was served or not. My lord, senior advocate of the central government, my lord, they have submitted before the contempt court that they have already released the money for implementation of the scheme.
Wrong, my lord. We have filed an exception to that, my lord. We have
They have
filed an
stated that-
affidavit. It is wrong. It is a wrong statement.
My
Whoever
lord,
has-
kindly see,
I'll bring a contempt.
kindly see page 21.
We have seen that. We have seen
Page 21, my lord.
We have seen that. That has been denied by them. As such, they are paying the salary from state fund.
Yes. No, my lord. That is not that. That is not that. But according to the scheme, National Health Mission scheme, central government is providing 60% and the state government is providing 40%. And my lord, that judgment which was submitted, my lord, this is in respect of the irrespective all allopathic doctor and my lord, the Ayurvedic doctor. Our, my lord, case is restricted who are engaged under the National Health Mission only. And my lord, the central government, that the Ayush Ministry and the National Health Mission, my lord, times and again, my lord, issued circular.
All right.
My lord, to add my lord, all the benefits.
The present appeal has been preferred, challenging an order ওটা
How they will, any other way to enforcement?
No, Malad, no, Malad, it's not about the enforcement, but Malad, since the order is, Malad, it may not be Malad.
আচ্ছা আরেকটা লাইন
Order is alive and a contempt proceeding we have stayed. But whether any other way to enforcement to file another
Yes,
petition or anything like that, if they file, you come.
Malad,
মানে একটা
if your lordship sees the nature,
moment, Mr. Bondor.
Malad, there's paragraph 41 kindly sees, Malad. Thereafter, your lordship passes the order.
Mr. Bandyopadhyay also informs this court that
Paragraph 41.
that in compliance of the directions passed by the learned single judge, uh, '39.
39, there are two issues here. 39 kindly first text. The principal secretary and the respondent number so are directed to ensure that the petitioners and all Ayush doctors in the state are paid the same remuneration and are treated so and so. Then 41. All
The 40 also.
Are Baba, please, Mr. Ghosh, please. How can this be a way of arguments? 41, all payments, salaries and emoluments henceforth to the petitioners. Therefore, if the order is not stayed, there are two problems. One is that other Ayush doctors will come and file in contempt. This is one way. And the other thing is that from January onwards, February onwards, we'll have to pay the remuneration. If not, they'll have a fresh cause of action again. Therefore, kindly stays the order. If your lordship feels that there is any illegality in the order.
My lord, kindly see the page, paragraph 40, my lord, also. That order is restricted only for the 6 writ petitioners.
Page.
Paragraph 40 of this judgment.
Yes.
My lord, the benefit of this decision, that is the difference in pay and computable allowances to the 6 writ petitioners shall accrue respectively from the date of filing of the writ petition on 16th April 2021. All the arrears payable to the 6 writ petitioner as directed above shall be paid to them within the period of 4 months. All payment salaries and emoluments henceforth to the petitioner shall be paid at par with all allopathic MBBS doctor who were contractually engaged along with the petitioner. My lord, this judgment is restricted not only for 6 writ petitioner, not for the all eyes doctors.
Earlier
39,
paragraph.
39.
But my lord, that
Directed to ensure that the petitioner and all the Ayush doctors are paid.
my lord, the paragraph 40, my lord, last portion.
Maybe order.
40
My
for
lord,
area
order is
calculation.
restricted only for 6 writ petitions.
40 is area calculation, is a different context also.
And my lord, only one thing kindly recorded that the central government has released the fund. My lord, that is my lord, the stated my lord.
But then
before
I'll have to place my affidavits in
বলতে দিন
contempt.
না।
আপনি তো এই সিস্টেমটা শেখালেন মাঝখানে ডিস্টার্ব করা।
You have disputed his contention. You have disputed such. You have disputed the
And my lord,
contention.
two things, my lord. They have paid till December, my lord, the half portion of
Mr.
that amount, that is
Mr.
within the region of
Bandyopadhyay
92
further
lakhs.
submits.
They have only paid 42 lakhs and odd.
Mr. Ghosh, it is not a case that you will be without service.
My lord, what?
Point has to be decided. We
My lord-
were initially inclined to stay the proceedings, but this is an order in rem which will apply to every Ayush doctor. Try
My lord-
to ascertain today if it is not stayed, it will lead to multiplicity of
My lord,
proceedings.
why I am submitting that? Because your lordship is recorded that what amount they have paid. My lord, till December, my lord, they have to pay 9 to 1 lakhs and odd.
ওইখানে
They have
page
paid only
যেটা বলেছো
42 lakhs.
সেখানে Mr. Ghosh opposes dispute
Yeah, for 6 weeks. Grateful, man.
Lordship, I beg to appear on behalf of the appellant petitioner.
That I am appearing on behalf of the respondent High Court administration being led by Mr. Siddhartha Banerjee. The difficulty is, my lord, owing to a medical emergency in the household of Mr. Banerjee. Mr. Banerjee had to leave the court today, my lord. He couldn't come to court today. I'm praying for a day's adjournment.
First time it has come.
Lordship.
What is
First,
Can
I am
1
for
stay
this-
application?
My lord, it is for our prayer to release the dues of the petitioner and also for allowing him
Why
to,
High Court administration?
my lord, because he is a bench clerk at the district judge's
So we don't have determination. It has to go
It's
to the chief.
for Chief Justice, your lordship.
district justice of Paschim Medinipur, subject to correction, right? District Judge Paschim Medinipur.
So it has to go to the Chief Justice's bench because we don't have the determination to ওইটা আছে না একটা কি আছে না ও আমাদেরটাই লেখা আছে excluding appeal from order relating to Roofsi's justice of service of judicial officers and staff of High Court service and district judiciary.
And then it has to go before that.
Both
bench.
retired and
Then it has to go before that bench.
হ্যাঁ হ্যাঁ দেখি ফাইলটা একটু দাও ওরে বাবা where is the petition? Where is the writ petition you have annexed? David.
The petition possibly starts at the page
My lord, it is
95.
page 90.
Page 95, you'll also make.
Page 95.
95, yes, 95.
No, no,
92, it
what had
begins
he
at-
challenged?
My lord, he
No, the
challenged there
disciplinary
are
proceedings
disciplinary.
culminating in the final order, which was challenged. The penalty was for 5 years. The
Time has
London
also
judge
expired.
has concluded the holding that the punishment has spent its force, so therefore nothing remains. That was our submission also. That's the petition has been.
Punishment has been
Yes, it was for 5 years. The
That is
5 years
over.
came to an end. That was over.
Now, he filed the writ petition. He was working where?
My lord,
But
he
it-
was working as a bench clerk at the district judge's court, under the district judge's court at Paschim Medinipur.
He is a district judiciary staff.
Lordship.
What was the punishment? Dismissal.
No, my
No,
lord.
punishment
He will not
was-
be transferred from Jhargram to his hometown.
What was his designation
My lord,
Bench clerk,
to
bench clerk 2.
in the court of
My lord, page 1 of the state petition, he has pleaded, my lord, the statement, my lord.
page?
On first page 1 of the state petition, Tapan
Yeah.
Bhattacharya, bench clerk 2, Judicial Magistrates Court, Jhargram, such and such.
Page 1.
Yes, the state petition he has said, my lord,
In the cost title.
in the cost title.
He is in service.
He is in service.
Acha, the present appeal arises out of an order. The present appeal arises out of an order passed by the learned single judge in a writ petition preferred by a bench clerk under
No, I'm for the appellant in this matter. Item number 10. 10 to. তুমি যাও তুমি রেসপন্ডেন্ট হ্যাঁ রেসপন্ডেন্ট আপনারা রেসপন্ডেন্ট আমরা এখানে ও করেছি ও সরি আমি ফর দি রেসপন্ডেন্ট
Milord, I am for the appellant, Lordship. In this matter, I am led by Mr. Devashish Chattopadhyay.
You have filed your opposition.
not I am fine.
Given
I have already submitted.
where is
already
your
handed.
reply?
Yes, Lordship, I kindly give us only 7 days extension to file the reply. Since there were some impediments, we could not file the
Mr.
reply.
Ganguly, learned advocate appearing for the state respondents, files the affidavit in opposition. Stop, let the same be kept, affidavit. করে দাও 19th March করে দাও on 19th March. Yes, next.
Grateful, Lordship.
11.
I am for the status.
দেখি একটু you are there, Mr. Ghosh?
Yes.
A list of dates. দুনিয়াতে কেউ নেই বুঝছি ঠিক আছে Lord, I have
Yes.
prepared a list of dates, list of dates, Lord, for your lordship's convenience, Lord.
Have they filed the report?
Yes. Reports are
That is a ready matter, man. Ready matter, man.
Reports are there on record, my lord, I'll point out.
My lord, this is a ready matter, man. Your lordship can take the matter. I am ready for it. Yeah.
Yes.
Yeah. My lord, kindly take the list of date. List of dates. Lord, what happened, Lord? This is a 5 kathas and out of land, Lord, recorded as Pukur. Lord, in course of time, Lord, in 1989, the original owner applied for conversion. Because it is already, Lord, there was no tank, but it was a lowland, became a lowland in course of time. What happened, Lord? On 31st February 2022, she applied, Gitarani, they applied for conversion, Lord, before the Urban Land Ceiling Authority, because it is within, Lord, municipal area, urban land agglomeration. What happened, Lord? There was it was a permission was given for conversion, and thereafter she sold the property to Ishwar Chandra Mondol in 1989, in 1990, and competent authority of the Urban Land Ceiling Act also, Lord, granted permission to transfer the property. Thereafter, what happened, Lord? There was a tap, water supply tap beside this low portion of land, and there was accumulation of water. As a result, this became a breeding ground of mosquitoes and other things. On the basis of a mass petition, the municipal authorities directed the then owner to fill up the low portion of the property, and it was done. Lord, the 3 persons, the entire land was sold to 3 persons. Lord, 2 persons thereafter, Lord, in the high portion of the property, they made construction of their building. Lord, only 3 cut has remained. Lord,
Ashok and Dev.
Hmm?
Ashok and Dev.
yes, Ashok.
Ishwar sold it to Ashok and Dev.
Dev
Then
and Molin and this Nomita Ghosh. Nomita Ghosh's portion, Lord, was low portion, and accordingly she applied for conversion of the property before the land reforms department.
so that portion was demarcated in respect of 3 persons.
Not sure, but portions were sold, undemarcated portion, but they have constructed.
Dev and Ashok has constructed.
Yes.
And in the space of
Nomita, that is not
lying vacant.
lying vacant.
Achha, then what
Till
happened?
now. Lord, your lordship kindly see that competent authority, that is the subdivisional officer, initially filed an application that was rejected, that it cannot be done, and thereafter appeal was preferred.
Mutation.
Mutation has been done. Conversion from, Lord, it has been recorded as Pukur. Pukur, Lord, from the BLRO's report, it appears not a report of 2010 that since 35 years it is being filled up by natural course, by throwing, Lord, garbages, etc.
In Nomita's portion.
In Nomita's portion, entire portions of the land, Nomita's portion, and Lord,
and Dev and Ashok are residing there.
Lord, that will appear from the report also. Lord, what happened, Lord? It was refused. It will not be converted. Thereafter, appeal was preferred. Appellate authority sought for a report from the Fisheries Department. But before Fisheries Department report reached the authority, appellate authority, he disposed of the appeal and dismissed the appeal. Against that, the petitioner before your lordship preferred an application before the LRTT. And LRTT, my lord, remanded the matter, set aside the order, say that you consider Rule 166 of the West Bengal Land Reforms Manual. Because of the fact that the municipal authority directed him to fill up the portion. That was ultimately, it was a report was sought for at the instance of BLRO, and considering the report, our application was dismissed. Against that, we have come. Now, kindly see the impugned order. Lord, I am placing before your lordship the first report of the BLLRO, Lord, which will appear at page.
Let us go through the order.
Yes, Lord. That is the last annexure of the writ petition. And Lord, during hearing of the matter by the other bench, there was further direction to the Fisheries Departments whether they have rightly given consent. Fisheries was explained and gave report that we have allowed, that it is not, it cannot be used as tank fishery. Accordingly, permission was accorded. That reports are there.
Why don't you file a compilation, Mr. Ghosh, enclosing the documents and the report?
Comes
in a compilation.
Lord, all the documents have been annexed. So far, the reports, Lord, during hearing of this application, Lord, the reports came. Those are.
No, this report is to the advocate concerned. This is what has been given to us.
No, report is annexed.
Report is annexed. Achha.
Yes.
Mr. Ghosh, come tomorrow. We have some contempt matters. Let us take it up.
All right.
Mr. Day, you have given one copy.
Lord, I think,
In my brief, nahi,
Lord, there are two copies, Lord.
It has been given to you, Mr. Ghosh.
They have been given.
So please make a copy of that and give to my
Yes,
brother.
yes, yes. I will.
Tomorrow,
Okay, Chennai. I sir.
not today, করে রাখবেন। Not today or Monday.
Lord, not,
my lord,
not,
not today, my lord.
not today.
Because Monday, my lord, on and from Monday, my lord, I have some difficulties.
Yes, doctor.
Yes.
এই পরেরটা এইটা রেখে দিও লিস্ট অফ ডেটস। 13টা কি আছে নতুন কন্টেম্প করছে।
It's my Lord's time.
Your Lordship, I am applying for the respondent number 2, kindly not today.
That is the Thika controller.
Not Thika controller, my lord, rent controller, from which we had preferred an appeal before the, my lord, in effect, my lord, we had challenged the order before the learned Land Reforms and Tenancy Tribunal. Therefrom, my lord, we have preferred this particular writ petition. Just praying for the not today, your Lordship. Give us 1 day time. Been taking adjournments on No, your several Lordship, occasions, your my Lordship, lord. I understand the urgency is kindly make it tomorrow.
All right.
Yes, yes, your
Very,
Lordship.
very,
Very good.
very
Yes.
Grateful.
much of this.
Take to another partner.
I am appearing for the contempt number 7.
Item 13, Your Lordship, I am led by Mr. Nilanjan Bhattacharya, Your Lordship. He is traveling. I'm seeking not today on his ground, Your Lordship.
Supreme Court already gives take. And this is the order of Supreme Court. I also had made objection that contempt petition is not in format. In respondent is 6, now contemptor 8, out of which 5 as new. How it can be?
My lord, actually, there has been some redesignations.
But how without
Some of
deed?
No, it has been stayed.
Yes, yes.
Yes, it has been stayed.
Take it to a contempt.
Lordship, I'm led by Mr. Nilanjan Bhattacharya for the Union of India, Your Lordship.
No role. Contemptor, let's say. In case of contemptor, you have no role.
Yeah. It's a contempt petition, please.
Not in deputy director, assistant director, they are not parties in the original OA or WPCT. Now they are contemptor.
This is that All India Radio matter.
Yes, my lord.
So their section 5 has also not been allowed. Condonation of delay.
It is within due time, my lord. Impugned order was passed on 25th June 2024. So 1 year has not passed yet.
In course of hearing, Mr. You are appearing for whom?
Contempt number 7.
Mr. Haldar, learned advocate, appearing
there has been some internal reorganization.
Are first go and fight it before the Supreme Court.
Yes, sir.
Akashvani did.
Yes, sir.
They're not state. It has been made returnable. Nothing has been considered.
Lord, I am appearing for the appellant and contempt petitioner, your lordship. I am being led by Mr. Siddhartha Banerjee, my lord. Owing to a medical emergency in his house, he couldn't come to court today.
Not this week.
Grateful, your lordship.
Both 14 and 15.
No, 14 and 15.
15, my lord.
15, 15, I am the contempt petitioner, your lordship. 15, they are the review petitioner, your lordship.
Oh.
I am the appellant,
Oh,
successful
correct, with
appellant.
that contempt.
তাহলে এটাকে তুমি review you have used your
Can you fix it tomorrow also on a review?
না review have you exchanged your
Yes, affidavit has
Affidavits have been exchanged, your lordship.
তাহলে next Thursday করে দিও
Grateful, your lordship.
হয়ে গেছে তাহলে ওই Thursday week করে দিও আজকে কি Thursday তো আজ Wednesday তাহলে 5 তারিখ না আজকে না আজকে তো 26 ওই 17-18 তে রেখে দিও 18th
Grateful, your lordship.
yes next
Lordship, I appear for the applicant herein. Lordship, on Lordship's order of which I'm seeking contempt was actually for consideration of my representation within a specified period of time. On the last occasion, I had submitted that a new incumbent officer in the BLRO office had taken charge and he was actually taking up the hearings. Now that hearing is being taken up. On the last occasion, they have handed us a copy of letter wherein the last occasion in order to rectify the record of rights has sought for permission from the DLRO as per 51 AC. So Lordship, all I was suggesting is if this matter can be taken up after a month, because by the point of time he says he'll be able to finish the correction. I have this thing on record with me, my lords. Something he's given a letter to the clients.
Proceedings has been initiated.
Proceedings has been initiated. So
And
what
hearing
happened
is
is
going
hearing is going on. It got delayed because a new incumbent joined, and that's something I may not join issues. I want the matter to end. Currently, this is a letter he's given to us on 7th of February. I made 2 copies for your lordship's perusal if your lordship just wants to see. He stated that as per 51A4, he sought for permission from the DLR. Now he's expecting that permission to come anytime soon. I was just suggesting if my lords can just keep it after a month.
you are for the petitioner
Petitioner, applicant. Lordship may just keep it after a month. I guess by the time the
So on your prayer we sent it out of list you mention after it is come
Lordship, the only apprehension, I'll just be candid to my lords, because this matter is before my lords and there is a returnable date, the things are happening at a blitzkrieg speed. That is the only indulgence I was
they are
seeking.
not complying which
No,
order
Lordship then
contempt
takes up the contempt application once.
yes you 5th July 2024 order
Lordship.
alleging violation
Lordship.
what did we say 5th July
Lordship,
In the
page 16.
16
of the contempt application, the Lordship takes up the last order
dispose of the representative
within 6 weeks. Now, because it was
when the next date has been fixed
Lordship, so may I just hand over this to my lords just for my lords perusal? Photocopy din na. Lordship, this is the last hearing happened on 29th of January. Thereafter, Lordship sees the last page, Lordship, the last paragraph.
you served upon the
Lordship,
commissioner.
they have been informed. He is aware, and the affidavit of service charge. If I'm not wrong, it has been filed also on the last occasion.
Now when he
Lordship, so he has not given a returnable date because he says he's waiting for permission from the DLR. Lordship, just kindly sees the last paragraph of the last page. If I just bring your lordship to the 6th line from bottom, where it is mentioned that if any incident or event has been left out only in the stage of preparation of RORs is felt necessary, only then the necessary correction of the BL and LROs may be allowed under 51A4 suo moto, of course, with prior permission of DL and LRO. Dealing assistant is required to take necessary action with a view to get permission from the ADM, LR and DLRO Alipur prior to starting of suo motu as per WBLR for plot number 4023. So Lordship, what he is doing is, what is written in his letter on the front page, he's waiting for that permission. Now, only indulgence I'm praying is, because this matter is pending, this is happening on a limited time.
Liberty to mention.
So I was just with that indulgence, Lordship keeps it after a month. I'm guessing they will get the, because that's what I have been orally instructed also from the clients.
You mentioned before that
Liberty to mention will
I'll
serve
come.
your purpose.
on the
That
prayer
I
of
can
the
mention.
on the prayer
Lordship,
of the
as
learned
it falls from your Lordship.
on the prayer of
The
the learned,
Lordship's intervention only, this is happening.
there is no specific order we have passed. Yes, sir. Needless
Lordship
to
had said
observe,
within 6 weeks. Now that was not considered. Hence,
uh,
that expired in the month of August. That expired in the month of August 2024, my lords. The Lordship sees then.
That was acting on the basis of taken up for taken up.
Lordship, that's 6 weeks of time. Lordship, that's 6 weeks of time.
proceeding number 10. This miss case has been initiated. Miss
Lordship,
case
this-
150 of 2023.
This was going on, my lords. This miscase was going on. Lordship, may I just assist your Lordship for 2 minutes? Lordship, we filed an application before the LRT. LRT said consider my representation. That was not being done. I filed a contempt application. Now that was being adjourned. We came up before my lords. My lords, upon getting instruction that they were actually going to that they completed the hearing in June, as my lord has recorded in my lord's order of July, they had completed the hearing on June. So my lord said only thing was remaining was to pass an order. They will pass an order within 6 weeks. Now interagnum, that officer has retired. So I filed my contempt.
Mukherjee, what purpose will be served by keeping the
I'll
contempt?
just give me 2 minutes, my lord.
There is no contempt then. So they have complied with the
Lordship,
order.
they have not disposed. Lordship's order is to dispose of my representation. They have not yet. They had already initiated a proceeding, which a final hearing had taken place on June. Lordship has recorded in my lord's order. Lordship just kindly takes up my lord's order once and reads it from the beginning. Lordship just kindly takes up. Page 16 of the contempt application, the order of which contempt is being alleged. My lord just sees the first paragraph. Learned advocate representing the petitioner submits upon instruction that the concerned PLLRO has already taken steps on basis of representation presented before him by the petitioner, heard the parties on 24th June 2024. Mr. The learned advocate appearing for the state represents also supports the petitioner contention and submits that the BLRO will issue final order shortly. On this basis, Lordship had asked him to issue the order within 6 weeks. Now, in the meantime, he retires. He does not give us the order. We file a contempt saying now again nothing is happening. Then a new incumbent comes in post. He says, I will finish it. Lordship, then I do not press the contempt application. I say, okay, let them finish it. On the last occasion, Lordship, he is now waiting for an approval from the DLLR. All I'm saying, my lords, is the hearing is completed.
The Mukherjee learned advocate appearing for the petitioner submits that pursuant to the order passed
In this matter, on the last occasion, your lordships were pleased to serve a copy upon the learned government pleader. We have done so, but now I have received an instruction from my client that they do not want to proceed with the contempt matter.
That Ms. Bhattacharya is not allowed.
Direction to file.
Your client has not misled us. He has filed the contempt making inappropriate submissions. Why should we allow now to withdraw?
This is the instruction I have received, if your lordship so.
My lord, in compliance with Lordship's order, my lord, we have filed, my lord, we are ready with the affidavit in opposition, my lord. Lordship was pleased to direct us to file, direct the DM to file opposition. There are two contemners. So, my lord, our opposition is ready. My lord, has served copy also upon the other side, Lordship. And 90 days.
On the reply, my lord, with humility, my lord,
I'm led by the learned
may
GP.
not have been received, my lord. I'm sorry, my lord, I could not be there, my lord. I'm a bit indisposed myself, my lord. Major toothache, my lord, I'm sorry. But my lord, I might have not received the reply. If my learned friend can hand over a reply to Mr. Galib, my lord, because we have not received the reply.
The petitioner does not want to proceed with the contempt.
My lord, the contempt is between your lordship and the petitioner, obviously, my lord. I don't have a say at this moment. But your lordship will see whatever the conduct, whatever your lordship wants to do. I'm here to assist your lordship.
Now, what is the present status?
Present status we had given for 90 days. It is.
Now he is working.
Yes, for 30,000 CFT.
The letter which specifies 60 days, that has not been corrected. But what I have received instruction, they have extracted for 20,000 cubic feet as of now. 10,000 is still left to be extracted. And since the letter, the termination date was 1st of March. So now they are left with they have not extracted the rest 10 as of now.
No, that 90 days is due to expire on 1st March 2020.
That was their option, my lord. If they wanted to, they could have continued.
Bhattacharya, learned advocate, appearing for the petitioner, submits, appearing for the petitioner, submits, upon instruction, that the petitioner does not want to proceed with the present contempt application.
Written instruction.
Let the written instruction, as produced be kept on record. ওখানে respondent alleged contemptor ওই অনির্বাণের নাম আর ওর নাম। In view thereof, the contempt application being such and such is dismissed as not pressed.
Very grateful, man. Grateful.
Lordship, this
কি বলছো?
My lord, our affidavit may be kept on record, my lord.
Maybe kept on record.
Let the affidavit in
opposition, man.
The affidavit in opposition filed on behalf of two contemners.
No, two containers, but Lordship was pleased to direct one container to
number one, my lord.
Number
one.
Alleged contempt.
Mr. Royal Learned Government pleader, appearing for the alleged contemners, files the affidavit in opposition of the respondent number one. Stop. Let the same be kept on record.
Very grateful, man. Very grateful.
চলো লিখে দাও। কোথায় গেল বলুন কি বলছি?
appearance.
ডাকু ওয়ান কি? আমাদের ইন্ডিয়ান টিচারে যাই কি কত শয়তানি করলো।
24.
24,
Yes.
Lordship. I am for the applicant, and in item number 25, Lordship, I am for the respondent.
20
on the last occasion.
25, yes.
Yes, Lordship.
You're for?
So I am for the 25, Lordship. I am for the applicant, and 26, Lordship. I am for the respondent.
Yes, where is Mr. Bose?
Lordship.
Vivekananda Bose
Yes,
appeared.
Lordship. Appearing for the respondent.
And Mr. Chatterjee, where are they?
He is there in the court number 24, Lordship. 25, Lordship. He is also. I convey the message that he will come, Lordship.
আচ্ছা দেখো তো এইটার ফাইলের ভেতর একটা রিটেন সাবমিশন দিয়েছিল মনে হচ্ছে না?
Paper book is there, Your Lordship. Fine.
হ্যাঁ শুনেছি তো এটা সাহা ইনস্টিটিউটের মধ্যে লোকটার ওটা কি তাহলে একজন করে দাও লিস্টে এমনি রেখে দাও টাইমটা থাকবে না এদেরকে ডেকে দাও
Since Your Lordship on the last location,
not today
Not today, not today.
Lord, under compelling circumstances, Lord, I am mentioning one matter for addition in my lord's list as for hearing. My lord, he is a very senior citizen. Very senior citizen of about 85 years of age. My lord.
I am not
Right. Kindly,
I am an opportunity to sit singly. Actually, when I shall today one contempt matter is there.
Yes, I know, but my lord, kindly adding.
The other. What is this?
The fixed matter one
Wait,
one.
Lord, I am appearing
Lord,
for the alleged
I'm filing
contemptor
the
with
affidavit of
Mr.
service
Dam.
as per your lordship's direction.
My lord, I am appearing on behalf of the alleged contemptor. Just today at 11:30 we received the notice. We cannot arrange to make him appear virtually as your lordship has. Yes.
Lordship, due to some technical error, I was not getting the server copy even yesterday 5 p.m. till. I got the server copy at around 7:30 yesterday.
Actually,
That's why today
that is
morning.
another aspect of the matter. When the order was brought to a notice. No, order was brought. Last occasion there was a direction to appear personally. He had appeared personally, entered his appearance before the register because your lordship was.
Whether he has entered appearance or not, he is bound to enter appearance.
Yeah,
Okay. Everyone who is residing in this area is due to.
Obviously, my lord. I bow down to your lordship.
Everyone.
I bow down to your lordship.
And none can be allowed to think he himself above the law of the land.
I bow down to your lordship.
Now, when the order was brought to the ministry, what about the compliance?
My lord, I have to take instruction. What are the steps?
Instruction order was passed such and such.
No, I know that.
You will face the music.
My lord,
consequence.
My lord, kindly give me one.
It is showing a good gesture to you.
My lord.
Then your appearance will be enforced.
My lord.
How to be enforced? That would be not proper to your dignity.
I bow down to your lordship. What has lordship has said. As an officer of the court, it's my duty to maintain the sanctity and dignity of the court. It cannot.
One statement.
No. As an officer of the court.
20th July 2023.
My lord, lordship, kindly allow me to.
Now, when it was brought to the notice, to your notice.
My lord, that was brought to the notice long back. My lord, I have to take instruction what steps has been taken for compliance, or whether it has been complied with or not.
Comply with or not.
Whether it has been complied with or not.
We know how to get our order compliant.
Yes, my lord. I bow down to your lordship. Lordship, kindly give me 1 week time so that I can come with instruction about the compliance of your order. Lordship's order, kindly, my lord. I got it right now. Kindly give me just 1 week time.
My lord, just one small indulgence. Today, my lord,
Except 6th.
Armed with an.
Allow the dignity of the court in such institutions to be lowered down by one such and such your client.
My lord, I bow down. I bow down to your lordship, my lord. I bow just.
SP Birbhum is not found to be competent to enforce your order. Then another.
My lord, just give me when I have entered. My lord,
and that would not be proper to your dignity. Whoever you.
My lord,
Court is annoyed.
I know your law.
The advocate standing behind you, he is representing the register of the cooperative society. He submitted specific submission that has been recorded, that instruction was given to you on behalf of the register of cooperative society to comply with the order.
My lord, it's my duty.
But you show till the date you have showed your audacity.
My lord,
show the compliance.
my lord, my lord, I got the notice right now, my lord.
You have so much powerful that you
No, my lord.
To Honorable High Court.
No, my lord. No, my lord, I bow down to your lordship. It's a duty to comply with your lordship's order when the order has attained finality.
Please just convey this message to your client that court will not take lenient view.
My lord, lordship kindly gave me 1 week time so that I can come with the compliance.
Lord, kindly fix us a date within 1 week then.
The second fifth. Okay. Fifth, same time.
5th March.
At the same heading and same time. Fifth at one. You convey this message.
It's my duty as an officer of the court to convey this message, my lord.
My lord, I am filing the affidavit of service pursuant to lordship's previous direction.
Affidavit service
My lord, kindly passes an order, my lord. Because my lord's direction on 19th was to file an affidavit of service. That's why. My lord.
আর না হলে করে দিন আচ্ছা ঠিক আছে একটা অর্ডারই করে দিন affidavit of service filed on behalf of the petitioner is taken on record ঠিক আছে stop Mr. Da, you are Mr. Da.
He is Mr. Dan. I am Mr. Dotto.
Learned advocate has entered appearance on behalf of the alleged contempt number 1. Stop. আর ওনার appearance-টা record করে দেবেন ঠিক আছে আচ্ছা stop. আচ্ছা Mr. Da submits that
Mr.
Place for one week time.
Mr. Dotto, my lord. I am Mr. Dotto.
Acha. Mr. Dotto, learned advocate, দুজন করেন না. Place for 1 week time. to avail necessary instruction to apprise the court as to whether the order has been complied with or
Fifth at this time.
not.
Obviously, my lord.
My lord, deeply obliged.
Actually, the contempt has already been committed.
Yes, I didn't know that.
And my lord, today, my lord, I was also.
If a court pass one interim order, even if after 2 months or 3 months the order is set aside, but in the meantime there will be violation.
Obviously, my lord. Till the date,
Judgment of Justice Sanjeev Banerjee.
my lord, till the date, the order has not
Yes.
been.
The order was alive, the order was binding upon you. Maybe it is set aside later on. But during that period, the violation is.
Obviously, the violation amounts to contempt.
Yes.
I know that.
At
1:05 p.m.
My lord, deeply obliged.
Appear personally?
My lord, he is a aged person, my lord.
There is no proviso for the aged person. No proviso.
My lord.
No proviso in the contempt of court.
My lord,
Kindly, my lord, passes
lord,
a specific
can-
direction to that effect.
To move. Unable to move.
No, your lordship, no. No.
Able
You
to
are an aged person, but not unable to move.
You are seeking some leniency.
No.
Then in that case, your lordship, he has to resign from the chairman's post.
Yes.
If he's so
My lord.
incapable of
Capable to run a cooperative society.
My lord, I completely agree with
kindly allow me
my
to come
learned
with
friend.
instruction on 5th. If I cannot satisfy your lordship may pass any order, and I shall be here to bow down to your every direction passed by your lordship. Any direction passed by your lordship. Kindly give me this 1 week breathing time.
Okay.
Even direction could have been passed today also. My lord knows it very well.
Okay, let's see. Learned advocate is saying.
And my lord, today, my lord, I was also armed with a judgment of Honorable Supreme Court.
Fuel to the
Just, just, my lord, one small indulgence. That judgment says, my lord, deeply obliged.
My Lord, before your lordship takes up, my lord,
One of you
we
will-
are, my lord, here to seek for your lordship's, my lord, grace, my lord. We had to
will
tender our
appear tomorrow.
appeal. Yes, my lord, we have come to learn of that, but it was our duty to come here, my lord. We tried also, but we could not. My lord, we tender our utmost apology, my lord. That is the only reason we are here. And additionally, my lord, we have come to learn that your lordships were looking for written notes, which we undertake, my lord, by tomorrow.
We are not looking for needed. After it was finished, he came and mentioned before us and said that I want to make further submission. As it was fixed as forwarders today, I
Oh,
expected they
one
will come.
document I will be showing, that's all. One document, lordship. Well, I'll show. My apologies, your lordship.
The scale which you have shown,
My lord.
you prepared a chart showing the scale only, which was the initial induction, make 2 columns, Joydev and such, and the scales in which they were inducted.
My lord.
Very good. Yes.
Grateful.
Review. Yes, Mr. Vance.
Yes, Lord, on a limited ground, Lord, review is maintainable. Lord, review is maintainable on the ground that there must be an error apparent on the face of record. Now, Lord, error apparent on the face of record, inclusive of the error of law, error of patent law. That is the law which was ignored, which could have been taken. And secondly, my lord, argument was advanced on the question of hearts, on the question of, my lord, that the conduct of the parties, that is section 20 of the Specific Relief Act. 3 judges bench of the Supreme Court held in all cases, the High Court is to look into the conduct of the parties, whether the specific performance ought to have been granted or ought not to have been granted. Now, my lord, conduct of the parties was argued, but no answer was given, my lord, in the judgment. Lord, I have, Lord, taken this point, my lord, in the review application. 2 points only I argue. That section 20 was not taken into consideration, namely the conduct, which I have argued. Because, my lord, I cannot argue on merits that or the judgment is erroneous on merits. Lord, my scope is very, very limited. Lord, ground number 1 in my review application. For that, this Honorable Court has committed an error apparent on the face of record in failing to decide core issue involved in the case that when defendant appellant herself denied existence of the agreement being void, 1, both in the pleading as well as in evidence, including the defendant's appellant's conduct to refuse execution and registration of the sale deed, even if money is paid in our evidence. Such conduct of the defendant itself is entitled to ask the court for exercising discretion in plaintiff's favor by refusing to grant a specific performance, although argued by failing to follow the Supreme Court judgment reported in so and so. Now, Lord, from your Lordship judgment, your Lordship kindly look to your Lordship judgment. From your Lordship judgment, my Lord, it doesn't appear any conduct. My Lord, it doesn't appear from that the conduct of the defendant, whether the specific whether he is entitled to ask that the plaintiff is not entitled to have a specific performance of contract. Because his contract is agreement itself is void. And second evidence is, my Lord, material evidence is, even if he pays a money, I will not execute and register a sell deed because I got the money from my retirement immediately after the agreement for sale. This is his conduct, her conduct. The very basis of the agreement for sale, my Lord, she denied. Now, Lord, question would be whether this point was argued before your Lordship or not, it is not possible for your Lordship to remind it. Mind, because so many, my Lord, cases your Lordship heard by this time. If, my Lord, within 2 or 3 days or 4 days after that, my Lord, the application is being heard, then it would be possible. And, my Lord, 2, for that the Honorable
It
Court
was
has
the judgment of 15-3 a WBL.
Lord, yes, Lord, I may place before your Lordship. Before that, my Lord, for the purpose of showing before your Lordship, because from your Lord, because of that, Lord, why I have filed an application before this court, Lord, because I have bitter experience, my Lord. When SLP is filed before a Supreme Court will say whether you have argued this point before the High Court or not. My answer would be, it does not appear from the judgment itself. Therefore, you go to the High Court to file a application for review. Lord, exactly, my Lord, Shankar Mondal case, Lord, Supreme Court held that. That is why, my Lord, I have filed the review application.
And what is your second ground?
Yes, second ground was that for that the Honorable Court has committed error apparent on the face of record by failing to look into material when 3 lakhs was paid from account pay from required amount is deposited. Balance lying lakh was deposited paid to the even amount was deposited from liquid cash in her business for which she need not carry amount in terms of the explanation of section 16C. In view of the fact lower court record in which exhibited document remained was not called for, such material evidence about conduct of the plaintiff was escaped attention of this Honorable Court. Because, my Lord, 3 months was directed to be deposited, failing which, my Lord, the suit will be, shall be deemed to be dismissed. I deposited the amount. I have annexed the copy of the, my Lord, passbook, my Lord, from which it does not appear any amount remaining in the passbook. But that amount I deposited then from the...
Where we have said that?
Yes. Lord, that I have in ground number 2. In the application, we have annexed those. Because in the review application, I cannot review, my Lord, in the form of a memorandum of appeal. That is why application has been filed. Lord, may I place before your Lordship my application to that? Application to Lordship, kindly come to Lord, page 100.
Just give us 5 minutes, Mister. 5 minutes. Let us go through the order.
Lordship.
এখান থেকে দেখিয়ে দাও।
As regards the money, where you are saying that you have referred to us that some receipts were there in the, that you have made further payments, where is that?
Lord, with regard to Lord, the payment,
You were the plaintiff
plaintiff,
in the suit for
yes,
specific
Lord,
purpose. Your suit was decreed. Now, when you came up in appeal, you are taking a ground that over and above the 3 lakhs amount, some other payment were made.
now Lord, 9 lakhs, the court directed in the degree to pay 9 lakhs
Very good.
within 3 months. I deposited within 3 months.
But that Mr. Banerjee, how it creates an error of law when we are deciding the
No,
application
because, my lord, my conduct is that because I am a
comply
businessman,
with the court's order.
Lord, my submission, because I am a businessman, and it has come from the evidence itself also, they admitted it, my turnover in the business according to income tax
Your
return.
turnover we considered. Your
No,
turnover we considered.
with regard to that, my lord, because I am a businessman, therefore I am not required to show money. I am not required to show money before the decrease in accordance with the explanation of section 16. That is the interpretation given by the Supreme Court.
Which
And my lord,
paragraph, Mr.
yes, my lord, before that, my lord,
Talking about the conduct, what was the case, plain case?
plain
What was
case,
the
my lord,
plain case and what was the memo of appeal prepared by you?
Lord, I did not prepare any memo of appeal.
What has been taken conduct regarding conduct any?
Lord, I have not prepared any memo of appeal. Memo of appeal there.
Memo of appeal they have paper.
Therefore,
So what is the plain? You have
yeah, therefore, conduct there would appear.
What was your plain case? So regarding contact, anything you have stated in your plain, you cannot go beyond the plain.
I cannot go beyond the plane.
Even before
Similarly, my lord, similarly, I
even
cannot
before
go.
So you say that
Yes,
what you are
Lord, I
saying,
will answer that.
such issue
Right.
was raised in your
Absolutely right, my lord.
Yes.
I cannot go beyond my plane.
Yes.
Similarly, defendant cannot go beyond its written statement.
If we have understood, Mr. Banerjee, your two grounds are, one was the conduct issue which we did not consider, and the second was your willingness, which would be expressed from your action in depositing the remaining amount pursuant to the decree, shows that your conduct was to go into there.
Because
These are
and
your
I
two
could not be, if the record is called for, then from that record it will appear that I have deposited that amount. I need not carry the amount. That is this is the law.
You deposited
My
after
account,
the decree.
Lord, my submission is income tax return does not show that I have I cannot argue on that.
Yes, yes.
Number two, melody is that from the income, from the current account, melody, from the savings bank account, melody, it does not appear that I have such amount of 9 lakhs. I have only account, melody, to the extent of 25,000. But
it is well settled that one person is not to carry the amount. It's not to carry the amount, but he is to get ready to register that.
Yes, I was ready.
Yes. Now it is you who brought the income tax return on record. Court or none has asked that you bring your income tax return.
Your lordship is
It's you.
absolutely
Only to show that I have a financial capacity to execute the deed.
Lord, my respectful submission.
Execute the transaction, complete the transaction.
My respectful submission on this is, my lord, that because he is an income tax assessee, if it is not filed, then adverse inference will be drawn. Therefore, I have filed it. But I did not file the passbook as well as the income tax return for the purpose of showing that I have money there. But I am a businessman, I employed that money in the business. That is my case. And I was always ready to perform the part of the contract. Now, this will be taken into consideration my conduct. And other conduct, my lord, defendant is that the agreement is void. And secondly, he said, even if he pays the amount, I will not execute and register a sale deed. Because her sister, husband Ajit, who was the defendant number 2, Lord, he said, I am occupying for 25 years. He has no right to the property. Lord, this is the conduct. This conduct
of a party is reflected from the pleadings
that was
and from the evidence.
Evidence I'm placing.
Court get occasion to infer about the conduct of a party to the suit.
Right.
Either from their pleadings or from their evidence.
Lordship, absolutely.
So
I will show that. Now, Lord,
whether the judgment was passed without considering pleadings and evidence.
Lord, my respectful submission.
Whether court has got any other source than the pleadings and
that
evidence
is source, my Lord.
To be considered to infer about the conduct.
That's right, my Lord. My first argument is that the argument with regard to the conduct was argued. That was not answered. Now, Lord, your Lordship, can it be a ground for the purpose of review? First point, my lord. Can it be a ground for review? Lord, first of all, my lord, I may place before your lordship the judgment of the Supreme Court in this regard.
No,
Lordship, kindly come to 2003, volume 9 HCC, page 519. Shankar Kumar Mondal. I have given that judgment to your lordship. Then, my lord, I will satisfy your lordship that what is the requirement of the law. Conduct is also required to be looked into, irrespective of, my lord, arguments. That was not, my lord, looked into. That therefore it is an error apparent on. But can I straightway go to SLP? Lord, that is the question came up for consideration before this Supreme Court. Lord, 2003, volume 9. My lord, I am reading, my lord, paragraph 12 of the judgment.
Page 2000.
2003, volume 9, SCC, page 519. 519. Shankar Kumar Mondal versus State of Bihar. Lord, in so many cases, at least, my lord, 3-4 cases. Lord, I'm telling you, Lord, at least 3-4 cases I went and moved the SLP. The lordship questioned me, have you argued this point? Can it be shown from the judgment itself? I kept mum because I don't find
that is the judgment. If within a short span of time you do not approach, it is not possible for a court to remember what was argued with.
That's right.
Yes, yes.
That's right. My lord, that is exactly.
You have missed that, boss.
Yes.
But now
Lordship, kindly come to paragraph 12, my lord. May I read?
Has not been considered.
May I read, my lord, paragraph 12?
Paragraph.
Yes. The final, Lord, I have given for
Yes,
your
yes.
lordship also. Two judgment I have given. The final submission of Mr. Ramamurthy was that several other questions were raised in the
which one you are reading? Shankar Mondal?
Shankar Mondal, paragraph 12.
12.
Paragraph.
Oh, achha. Oh, the quotation.
Quotation. The final submission of Sri Ramamurthy was that several other questions were raised in the writ petition before the High Court, but they were not considered. We attach no significance to this submission. It is not unusual for parties and counsel to raise innumerable grounds in the petitions and memorandum of appeal, etc., but latter confine themselves in the course of argument to a few only of those grounds, obviously because the rest of the ground was considered even by them to be untenable. No party or counsel is thereafter entitled to make a grievance that the grounds not argued were not considered. If indeed any ground which was argued was not considered, it should be open to a party aggrieved to draw the attention of the court, making the order to it by filing a proper application for review or clarification. Time of the superior court is not to be wasted in inquiring into the question whether certain ground to which no reference is found in the judgment of the subordinate court was argued before that court or not. In usual course, a stance taken before this court would have been ignored in view of the settled position of law indicated above. But in view of the fact that in connected matter, directions have been given for consideration of the age aspect, it would be appropriate if similar consideration is made in respect of the appellants. Therefore, my remedy, my lord, is to make an application before this court.
Now, what is the thing you argued and we did not consider?
That's right.
Yes.
Lord, now, my lord, this is the point which I...
If you can show us, we
yes,
fall within the parameter of this judgment.
Lordship, kindly come to the, first of all, my lord, I may place before your lordship that I am a businessman.
Now, Mr.
admitted
we will go to the documents. Please tell us what is the point you argued and we did not.
Yes. Lord, this point was argued about the conduct of the defendant.
I see.
Page 56. I need not read entire, my lord.
Just now, your argument is the point you argued was about conduct.
Defendant's conduct was not taken into consideration.
That was taken. Yes.
And therefore, defendant is not entitled to argue before this court that I am not entitled to have a decree of a specific performance of contract, because a decree of a specific performance of contract is a discretionary jurisdiction on the part of a court. Like, my lord, Order 39, Rule 1, Order 40, Rule 1, These are all
So
discretionary
in view
jurisdiction
of the conduct, discretion ought not to have been
or not to have been. Therefore, conduct is also to be looked into in all cases. Now, my lord, your lordship, page 56. If the plaintiff makes the entire payment of the rest,
Page
even then,
50?
page 56 of my application,
Yes.
Lord, towards the bottom. If the plaintiff makes the entire payment of rest, even then I shall not execute the deed of a conveyance in favor of the plaintiff, because I have received the retirement benefit. So I do not require money at present. And my lord, this is the conduct, and his case, further cases, that is your lordship have already discussed, that void. Your lordship, Lord, very nicely, my lord, interpreted. It is not a void. Voidable at the instance of the promisee. Your lordship interpreted that part. But the conduct of the defendant, it is a void. From the very beginning, the agreement is void. And secondly, he said that even after that,
We have not accepted that point, that it is a void agreement.
I have not accepted. I said that it is a valid agreement.
Yes.
Conduct of the defendant is, it is a void agreement.
That was his argument.
No, this is his, this is in his written statement also they pleaded. It is a void agreement. Why? Because 1 month time. Therefore, it is void. Then they wrote a letter, your lordship discussed in the judgment, wrote a letter cancelling the agreement unilaterally. Your lordship held cannot be. Therefore, I am not on that. For the review application, I say that his case is void. Very document itself he is challenging. Secondly, my lord, he says that even if money is paid, I went there to pay money. Now, even if he paid, I will not execute a registered sale deed in his favor, because I have the money in terms of my retirement benefit. That is the conduct on the part of the defendant. And third, my lord, is he set up his daughter, his sister, saying and arguing before this court that property was in his occupation since for last 25 years.
How that can be a ground of review?
Yes,
Mr.
that is your lordship. Kindly look to the judgment of 2015, volume 2 SCC. Lord, I have placed that, my lord, in my review application. Lord, first of all, my lord, 15.3, ground number 1.
15.3 SCC?
15 volume 1 SCC, my lord, this is WBLR, is it equal to 2015 volume 1 SCC, page 705. Now, Lord, I am placing that judgment before your lordship.
Treat the time as the essence of the order. We accept it. But we exercise our discretion, holding that he was proved to feel that he was ready. She was ready.
Lord, paragraph 24 first.
Mr. Banerjee, we are just, this issue of being void was not your issue. It was Gauri's issue. You are the plaintiff. Josna is the plaintiff. Josna filed the suit for specific purpose. In your suit, you did not argue that the agreement is void. That is the challenge of their challenge, the defendant.
Lord, Supreme Court pressed on the point that in that case, in those cases, Lord, that when the very basis of the agreement he has challenged, and he denied the agreement, this itself is a ground that he is not entitled to claim that plaintiff is not entitled to have a degree. But degree for a specific performance was granted. Lord, I am to the point, my lord. I am to the point. Lord, this is their case. That agreement is a void one.
Where is that ground of yours in review?
Lord, ground in my review, my lord, ground number 1.
Yes, ground.
Now, ground number 1, my lord, I am.
It is a combined ground. You have conduct and discretion, you have included it. This argument, which is a far more refined argument than the ground which is being said. So the ground, Mr. Banerjee, is not.
Lordship. Lordship power is a sterile power, my lord. Is always there.
No, why?
The way
No.
If you satisfy us, there is the error of the record.
You are such a senior counsel. You have argued civil matters for how many decades?
Lordship.
We are here to understand from you. If we
Lordship,
have made
lordship.
any mistake, we will
Lordship,
correct.
lordship. Lord, your lordship, kindly come to paragraph 24. Why I am saying this? Because 16C explanation. It is the duty on the part of a court to look into the conduct, irrespective of argument.
Paragraph 16.
Paragraph 24 first. Yes, my lord. Paragraph 24 first. It is well settled that remedy for a specific performance is an equitable remedy. The court, while granting decree of a specific performance, exercises a discretionary jurisdiction. Section 20 of the Specific Relief Act especially provides that the court discretion to grant a decree of a specific is discretionary, but not arbitrary. Discretion must be exercised in accordance with the sound and reasonable judicial principles. Now, my lord, your lordship, kindly come to straightway, my lord. Paragraph, Lord, 33 and 34. The equitable discretion. Equitable discretion to grant or not to grant relief of a specific performance also depends upon the conduct of the parties. This is silent, my lord. In the judgment, my lord, this is silent. Lord, that is why review. And my lord, your lordship knows, Lord, with regard to the interpretation, ওই কেসটা গো যেটা সুপ্রিম কোর্টের জাজমেন্টটা ওই এটা ওই যেটা নিলাম 2015 ওই যে এটা হ্যাঁ Lord, let me read and then may Lord I place before your Lords. 33. The necessary ingredient has to be proved and established by the plaintiff so that discretion would be exercised judiciously and in favor of the plaintiff. At the same time, if the defendant does not come with clean hands and suppresses material facts and evidence misleads the court, then such discretion should not be exercised by refusing to grant a specific performance. Blood, here I am joining the issue. Blood, he is conducted, it is a void agreement. Secondly, he says that even if he pays money, I will not execute and register a sell deed. Thirdly, my lord, he set up his sister, her sister. Lord, argued before your lordship for the first time in the court, in the trial court, they did not contest. They came before the court and say that we are in possession and he has no right to the property. We are possessing for last 25 years. Ajit Das.
It is the
Ajit is the sister's husband.
Sister's
husband. Number they bent upon not to execute the decree even after the sale consideration money is paid by the plaintiff to the defendant. This is the conduct. Fourth is, my lord, during the appeal, during when the payment was made, he was given a notice to execute and register a sell deed. He did not. Then court executed and registered a sell deed. Cell deed was executed and registered. Lord, this is apparent on the record itself because lower court record was not called for. This is also a conduct on the part of the defendant. Lord, and even, my lord, this court repeatedly asked, my lord, earlier bench that pay the market value and settle it. Even if, my lord, court proposes that this is the market value I am giving, are you agreeable? He said, no, I will not execute and register a sell deed. He was bent upon to do that. Lord, mediation, it was sent to the mediation. He did not agree. Because he said that even if money is paid, I will not execute and register a sell deed. This is the conduct, this sort of conduct. Now, my lord, this point obviously, my lord, cannot be argued in the review application. This can be argued in the appeal court. Appeal court. But this is a point, my lord, which was not spoken, my lord, in the judgment. But paragraph 33, then 34, in the instant case are noticed above. Although defendant 2 held a registered power of attorney on behalf of the defendant number 1 to sell and dispose of the property, but the defendant not only made a false statement on affidavit that power of attorney had authorized the second defendant only to look after and manage the property, but also withheld the power of attorney from the court in order to misguide the court from the truth of fact. Further, by the registered agreement, agreed to sell the suit premises after receiving advance consideration, but they denied the existence of the agreement in their pleading. Lord, in our case also, existence of the pleading because it is a fraud. Lord, I can produce before your lordship agreement, written statement. Denied the existence of the agreement. Denied the existence of the agreement in their third conduct of the defendant, in our opinion, disentitled them to ask the court for exercising discretion in their favor in refusing to grant a decree for a specific performance.
Yes.
Now, my lord, my respectful submission is that under section 20 and under section 16C of the Specific Relief Act explanation, Lord, this has been, Lord, interpreted by another judgment. I am placing before your lordship that judgment that in all cases it is required to be looked into. This is the law. Lord, 3 judges bench, Lord, AIR 1967 Supreme Court page 868. Lord, this is 3 judges bench. Lord, question of conduct was looked in. Question was whether he is required to bear the money, to show money to the court in order to enable him to get a decree of a specific performance of contract. Lord, your lordship kindly look to the judgment. I shall place before your lordship this judgment. Lord, trial court, Lord, he had no money. He was not willing to perform the part of the contract. Paragraph 8, my lord. Trial court judgment. Page 878, my lord, paragraph 8. At the trial, the respondent asserted that April 15, 1959, he was willing to take the sell deed from appellant number 1 to 2, but on April 30, 1959, he was not ready to purchase the stamp paper and take the sell deed. Somewhat inconsistently stated that on 30 April 1959, he met the appellant and called upon them to execute sell deed. An appellant told him that he had urgent need to go for the case and that he would get possession only later and the sell deed would be executed after his return. The trial court considered the plea and the respondent was not ready and willing to perform his part of the contract. On the putting that time was not of the essence. The court referred to the admission made by the respondent that he was not willing to take the sale deed on April 30, 1959, and then considered the question whether the sale deed was completed by 30 April 1959 on account of default on the part of the respondent or the appellant 1 and 2. On a consideration of the evidence, the trial court came to the conclusion that the respondent was not ready to complete the sale by April 30, 1959, since he wanted time for consulting his lawyer as to the desirability of obtaining attestation of the children of appellant number 1 in the proposed sale deed, and the appellant 1 and 2 did not ask for postponement. Trial court then proceeded to consider whether default was committed by the respondent and by the appellant number 1 and 2, and observed mere assertion in the plaint that he was ready and willing to perform the contract was not sufficient. His readiness and willingness had to be judged from what he had done, from his conduct subsequent to the agreement, and on a review of the evidence came to the conclusion respondent committed default by not carrying out the contract on so and so date, and even after April he was not willing to perform the part of the contract. Lord, thereafter, my lord, it was dismissed. Then, my lord, High Court, my lord, set aside the decree, and High Court, my lord, restored the set aside the decree and granted a decree of a specific performance of contract. Then ultimately, my lord, paragraph, my lord, 18. Lord, I need not read the entire judgment. Paragraph 18 of the judgment. After discussing the evidence, trial court recorded the following finding. Then, my lord, trial court finding is recorded here up to this time. Then I am of opinion. Then, my lord, the opinion of the trial court, Supreme Court, my lord, I am of opinion, trial court was clearly wrong in inferring that the respondent was not ready and willing to perform the contract from the fact that from April 30, 59 to middle of July, respondent had not taken any steps in the matter from his failure to explain the delay. If the respondent was guilty of laches, it was the duty of the appellant to fix a reasonable time for completion of the sale. Lord, here in our case, Lord, he straightway wrote a letter to cancel the deed, saying it is a void deed. I am hereby cancelling this deed. Not fixing a date that by this time you deposit that amount. He did not. Then mere delay sort of waiver. Lord, possibly your lordship by this time read it. 50 Federal Court judgment. 50 Federal Court, page 90. Privy Council. Privy Council decreed a specific performance of the contract to sell shares on the question of readiness and willingness of the buyer to perform the contract. Lord so and so, it is true that first plaintiff had stated that he was buying for himself, that he had not sufficient ready money to meet the price, and that no definite arrangement had been made for finding it at the time of repudiation. But to prove himself ready and willing, a purchaser had not necessarily to produce the money or to vouch the concluded scheme for financing the transaction. Paragraph, my lord, 18, my lord. Right hand column towards the bottom. Right hand column towards the bottom. Privy Council judgment, my lord, was quoted and approved on the question of readiness and willingness of the buyer to perform the contract. Lord so and so of the report held, it is true that first plaintiff had stated that he was buying for himself, that he had not sufficient ready money to meet the price, and that no definite arrangement had been made for finding it at the time of repudiation.
Yes.
But he ought to, because he ought to have given a notice on that you pay money within that time in a state of cancelling the LD. And when I went there, Lord, he said, even if he wanted to give money, I will not execute and register as LD by accepting the money. Page 56 of his deposition. That is the conduct, my lord. That was not taken into account. But to prove himself ready and willing, a purchaser has not necessarily produced the money or to vouch the concluded scheme for financing the transaction. In my opinion, A respondent is entitled to a specific performance of the contract. High Court rightly decreed the suit.
Yes.
Now, Lord, my respectful submission is that under section 16 explanation 1, Lord, I may place before your Lordship 16 explanation 1. Lord, only 3 grounds I have taken, my Lord, in the ground of review, my Lord. The 3 grounds and 4, my Lord, with regard to the registration of the sale deed by depositing the money. Because post-litem fact, my Lord, admitted post-litem fact can also be taken into consideration at the time of disposal of the appeal. But since the lower court record was not called for, therefore I could not be able to produce that materials before the court. Ground number 4 is this, and 3, my Lord, is with regard to
readiness and willingness.
Readiness, financial resources are available from the business. Fail to decide readiness and willingness having regard to the facts and circumstances. Lord, from the business, whether from the business I can procure the money, that was not taken into consideration, that part. And my Lord, in this case, my Lord, I may place before your Lordship my document, my Lord, my application. Your Lordship kindly look to my passbook. That in the passbook there was no money, but I have cash money deposited, Lord, and deposited that amount of 9 lakhs because I am a businessman. Lordship kindly look to, my Lord, the page, Lord, page 131. (132) and 133, my Lord, that we have deposited the amount before the trial court.
Yes.
Lord, page
Yes,
1.
you have deposited, you had deposited the amount as per direction of the trial court. Yes.
Because I wanted to
This
show,
was brought to our
I wanted to show, because I am a businessman, I collected money, deposited, but in my account nil. At that time, no such amount was there. I'm a businessman, I'm able to pay. If you write a letter by saying that instead of cancelling it, pay within 7 days, I can deposit that amount to him.
That
Therefore, I was not.
Our decision regarding your financial capacity or capability, we cannot sit over that.
No, financial capacity, my Lord, with regard to financial capacity, my Lord, your Lordship, Lord, looked into the angle from the income tax return and the Lord, I cannot right, my Lord, I cannot insist your Lordship to
justify
give you
the
that,
same or to
justify that. If it is erroneous, even if it is for argument's sake, say that it is an erroneous finding, even then I cannot.
You cannot.
I am not entitled to argue that.
Yes.
Simply I am arguing, my Lord, on the basis of the conduct. And with regard to that, I am not required to produce money.
Yes.
And Lord, another judgment, my Lord, I may place before your Lordship, that conduct as well as carrying money and to show money is not the
carrying money,
requirement of the explanation of section 16C(1).
Yes.
Lord, my argument is on purely on question of law, my Lord. That on, I am not saying your Lordship will reconsider it. Or on the other hand, rehear it, the appeal. No, I can't. I want to say that under section 16C explanation, I am not required to show money, that this is the money I have.
Yes, 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 yes.
The law laid down by the Supreme Court, no, I am not required to show. If that is so, my lord, if your lordship agrees with that, my lord, then in that case, my lord, I may successfully say it is because that question was, Lord, not touched, not taken into consideration, that can be an error apparent on the face of the record. Lord, 16C explanation 1. Where a contract involves the payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit in court any money except when so directed by the court. Therefore, I am not required. Then the plaintiff must have a performance of and readiness, willingness to perform the contract according to its true construction. Now, Lord, I may place before your lordship, this interpretation of this explanation has been made by the Supreme Court. Only that part I can place before your lordship. And I am aware that the judgment of the Supreme Court is before the judgment is delivered. Lord, if any judgment, Lord, of the Supreme Court is delivered after the judgment delivered by your lordship, contrary to the principles, then, my lord, under order 47 rule 2, my lord, I am not entitled to place that. I am not entitled to place that. That is why I am aware of that, my lord. Your lordship, kindly look to this. Lord, 2022 online Supreme Court, Lord, prior judgment was quoted. Lord, 99, volume 6, Supreme Court cases, page 337.
Which
Lord,
one?
I have brought, first of all, my lord, because your lordship
You are
may-
referring to 22 SCC or
99, yes, 22 SCC online, my lord, refer to 99, volume 6, Supreme Court cases, page 337, 3-judge bench of this court. Lord, now, how it has been Lord, paragraph 16, Lord, that has been quoted from that, and then paragraph 22, concluding paragraph. Lord, 99 I have brought it, my lord, for your lordship, 99.6. May I place before your lordship 99.6? Then I shall come back.
No, para 22, paragraph 16, it was dealt with.
It was stated.
You can show us para
I
20.
thought your lordship possibly is searching that. Lord, that is why 99 I have.
No, it's okay.
Submitted before your lordship to help your, satisfy your lordship.
Yes.
But then your lordship kindly come to paragraph 22.
Yes.
Your lordship read that. This is the vital point. Having said that, let us examine the facts of this case. Discussed earlier, the respondent plaintiff had not only averred in the plain about his issuing notices within the period of 6 months of the agreement in question, calling upon the transaction or readiness and willingness to perform his part, but respondent has also proved the same by stepping into witness box. Though the reliance was placed by the learned counsel for the appellant on the decisions of this Ritu Saxena, in case that the respondent had failed to establish his financial capacity to pay the balance amount of consideration at the relevant time, and also failed to deposit the amount in the court at the time of filing the suit, he was not entitled to discretionary relief. Specific performance as granted by the court. But this is the question. Financial capacity at the relevant point of time. Lord, argued 2019 SCC placing that. Lord, answer is, we do not find any substance. Do not find any substance in any of the said submissions as per ratio of the judgment laid down in the 3-judge bench in the case of Sohi Dastogir Supra, that is 99 volume 6 SCC. The compliance of readiness and willingness has to be in a spirit and substance and not in letter and form. While making averments in the plain, as per explanation 1 of section 16C, he need not tender to the defendant, nor deposit the amount in the court. He must avert the performance or readiness and willingness to perform the contract according to its true construction. Therefore, my lord, their argument with regard to that part, Lord, the financial capacity to pay balance amount, Lord, that is not required under the law. If that is not required under the law, my lord, then this is an error apparent on the face of the record. And my lord, so far this point is concerned, I think, my lord, I need not argue before your lordship, because your lordship knows the latest judgment of the Supreme Court in Money Square case, Money Square. Lord, Money Square case, Honorable Justice, Lord Bhattacharya, my lord, held that lease is beyond 12 years. In respect of it must be in respect of a vacant land. But it was not in respect of a vacant land, but along with structure.
Yes.
Therefore, it does not come within the definition of thika tenancy. But then it went to the Supreme Court. Supreme Court delivered a judgment saying it is a thika tenancy. Now, Lord, what the Supreme Court has said, Lord, the judgment has been. Lord, your lordship, kindly look to the judgment, my lord. Lord, 2021 Supreme Court 3055. Lord, ultimately, my lord, in Money Square case, after the review was allowed, my lord, the Supreme Court, my lord, approved the view of Honorable Justice Jyotirmoy Bhattacharya. Lord, paragraph 4, my lord, of the judgment will be enough, my lord. One of the paragraph 4, one of the accepted categories in section 2.5 postulates that the definition will have no application to lease beyond 12 years period. On this count alone, the finding of fact recorded by this court in the judgment under review and the declaration given in favor of defendant respondent number 1 on that basis cannot stand, being a manifest error apparent on the face of record and also contrary to the express statutory provisions. Lord, that is why review the question whether appellant in civil appeal could otherwise succeed On other arguments, including that they had protection under the Calcutta, Lord, these will be decided in the main appeal. That is why, my Lord, review was allowed. And my Lord,
Yes.
and my Lord, the judgment of Honorable Justice Bhaskar Bhattacharya presiding the division bench here is that there was a judgment of Lord with regard to interview marks, oral marks, Lord 12.2% must be there. Lord, in that case, Lord, two judges bench of this court, Lord, held in relying upon the Supreme Court, that is also two bench judgment of the Supreme Court, held that 20 marks would be enough for viva voce test. The Honorable Justice Bhaskar Bhattacharya held this is an error apparent on the face of record because Ashok Jadhav case is three judges bench. Therefore, this is an error of the law. Court bound, division bench will be bound by the judgment of Ashok Jadhav. Lordship, kindly look to the judgment, only the paragraph, main paragraph.
But how that applies in this?
Applies this, that because, my Lord, in view of Section 16C, I am not required to carry money. I am not required to a status of financial capacity.
You have said, Mr.
Under
Paul.
the law, I am not required to show my financial capacity. Lord, my argument is I am not required under the law to show financial capacity.
Yes.
Second, my Lord, when the trial judge already granted a decree, whether or when it is, because appeal is a continuation of the suit. And my Lord, when appeal is preferred, Lord, judgment notwithstanding, because appeal court is sitting over the hearing of the suit. Sitting over the hearing of the suit. Now, question is, the conduct is to be looked into in terms of Section 20. Conduct of the defendant will also be looked into. Not only this, Lord, ingredient 6, Lord, that has been given in 99, volume 6 SCC.
Yes. All right. Yes. What is?
My lord, kindly turn to page 5 of the judgment of passed by your lordships, wherein, my lord,
Which paragraph?
paragraph 14 of the judgment. There, my lord has whatever submissions Mr. Banerjee has made before your lordship, that has been noted. Mr. Banerjee appearing for Josna referring to relevant portion of the agreement for sale, and as relevant portion submitted that time was not essence of the contract. And Gauri deposed that even after issuing the letter dated, she met with Jesna with a request to execute and register the deed, and Gauri to treat them essence of the contract he submitted. Gauri had stated the relevant papers were not handed over to Josna prior to. After dealing with this, my lord, your lordships, after considering the submissions made therein, my lord, in paragraph page 8, so far as my argument is concerned, that the time is the essence of the contract, that has been, my lord, held negative.
Paragraph?
Page 8, paragraph 20. Then, my lord, after considering the entire case, my lord, your lordship has come to page 8, 9, 10. The relevant provision, Gauri raised one plea that Josna was not ready and willing to contact section 15C of the specific relief act.
Page,
Page 10, paragraph 26. Therefore, my lord, the entire submissions of Mr. Banerjee and so far as the relevant consideration was taken into consideration. And for the first time before the review court, my lord, he is making prayer. He has never argued before this court that he is not entitled to even. Because I have taken the plea that the agreement has become void in view, the agreement is not executable at the relevant time because the time was the essence of the contract and that has expired. Therefore, my lord, on that plea, he has not played that I am not entitled to pray any discretion before the court. The discretion should not be exercised in my favor. That has not been. Therefore, my lord, the question of review does not arise at all because the point he is making for the present, my lord, that is, my lord, with regard to not a discovery of not present.
New and important matter or evidence.
This is not an error apparent on the face of the record. And my lord, all these questions were considered.
Where did we consider the conduct?
The conduct, my lord, he has never even argued. So far as the conduct is concerned, my lord, the conduct was that the petitioner has taken award in his written statement that the agreement cannot be executed for the present because the agreement has lapsed in view of the fact that he could not perform his part of contract during the period because time was the essence of the contract. But your lordships has taken into consideration that the time is not the essence of the contract, but she is not entitled to get relief because she was not ready and willing to perform her part of the contract as required under section 16 in view of the fact that she has no fund to. After the material which was placed before the court, my lord has taken into scrutiny and therefore, my lord, your lordship. Therefore, the question of this was never argued even and my lord, this point was not taken. My lord, therefore the question of review of the judgment, my lord, on the ground that this is a de novo trial, my lord, he is making submissions before your lordship. And my lord, that cannot be accepted, my lord, and further conduct. My lord, I am referring before your lordship a recent judgment reported in 2023 1 Indian Civil Cases, Supreme Court, page 95. My lord, I am handing over a copy of the
Position.
He is not entitled to, my lord, to repeat an old overruled judgment, my lord. That was taken into consideration and when your review cannot be, which cannot be detected by a process of, cannot be described as an error apparent on the face of the record. My lord, so far as Mr. Banerjee's contention is that the court has not taken into consideration everything has been, my lord, from the judgment itself, it would appear that whatever he has made submission, that was taken into consideration. And every material has been taken into consideration so far as the agreement is concerned. And my lord, he cannot reopen by way of review, my lord, because section 47 nowhere prescribes such power.
Yes, thank you.
My lord, I am for the defendant number 2.
Who are you? Ajit.
Representing Mr. Ajit.
What you have to say? Not required.
I will refer two judgments.
Not required.
Not required.
That is a recent judgment, just passed. Just go through this. Here the interpretation has been provided. And all the judgments is referred.
Respondent number 2 করে দেবে।
And the new interpretation of the what is the error on the face of record has been given. Para number 11. The relevant para is para number 11. Para number 12. Para number 21. Para number 21. Line number 5. Fifth line. It was further held that an error apparent on the face of the record must be such an error which must
These are principles settled for
Yes,
the
it is
last 4 decades.
Yes, it is settled.
So you need not repeat that.
No,
You
that is
check
reinstated
What is
again.
the paragraphs we are referring to?
Para number 21.
Yes.
So that's the paragraph. I have already marked all these things. These things are already settled. So he's just opening the trial.
Yes.
That is my concern. He's supposed to go for the appeal.
Lord, may I give?
Yes,
Lord,
yes,
may I
yes.
give short reply with regard to the judgment my learned friend has referred, 2023 volume 1 SCC. No, Indian civil cases, page 95 Supreme Court. Lord, the proposition of law here I am not disputing. Secondly, my lord, here in this case facts are different. Facts are
Yes, yes.
facts are totally different, distinguishable on
Here
facts.
the scope has been
Now,
given.
my lord, the
So what is the
question,
scope of the review?
question is, my lord, Jabina Siddiqui. Jabina Siddiqui's case, my lord, even if, Lord, supposing your lordship cannot remember this, that this was not argued by Mr. Banerjee, maybe, Lord, because your lordship not possible to remember. Even 2-3 days after, because so many cases, Lord, we are dealing with 1 or 2 cases or 3 cases in a day.
No,
But
you deal with much more cases. With much more cases. Like they are.
Lord, here, the Siddiqui's case, my lord, it is the duty on the part of a court to look into the conduct. And with regard to readiness and willingness, financial capacity need not be looked into. These are the 2 legal points I am arguing.
The respective parties have concluded their arguments.
So far, Mr. Banerjee's judgment is not applicable immediately.
Right, right. Right, right, you are.
Readiness.
Lord, I am sorry, my lord, I could not be able to attend on the last day because I was admitted to hospital.
You're all right now?
Now, my lord, all right. I was for 5 days more, my lord. And thereafter I came.
Now you're all right.
I'm
Mr.
willing.
Is that one next to that?
Lord, I'm deeply up.
Lord, it is the matter. I have concluded my argument. State is supposed to answer this. I have concluded that this is the matter, my lord. Can you recollect where I have challenged the alleged award on threefold ground?
Sons have come. The lady expired, the sons have.
No, here, my lord, what happened? Yes. And
Who was appearing for this state?
Your other side.
Mr. Bandopadhyay is appearing. He has come to court, but not feeling well, my lord. Let it be posted next week, any day, according to convenience of other side.
We told him to bring something, no?
yes. Now, my lord, tell your lordship what happened.
No, what did we ask him to bring?
But tell your lordship. My lord, there, my lord, I have challenged the award on threefold ground. That section 3 notice was not served upon me. And our alleged award is a piece of paper without complying the rules framed under the rule 30 form 31. And thirdly, my lord, that without apportionment award is nullity. And I cited the judgment before your lordship. On that score, your lordship directed them to produce the copy of the award. That where is that?
Have you called for those documents?
I am not in this matter, my lord.
He's sitting in the room.
No, he just told me I am not feeling well.
Just now told you.
No, at the TP notes. And he also told them.
Next week. Yes, next.
Award copy. Deeply obliged, my lord.
2 weeks করে দাও।
কে? জজ সাহেব যা বলবেন দেখো নেক্সট উইক বলতে
19 next week করে দাও। কি বললাম next week বলেছি 19
Thursday.
Mr. Pan your was 18 না?
18.
Next week 18 next week 19 who is there?
18
Yes, next 19 BP Subha.
19, Lord, I appear on behalf of Lord the appellant. Is that Kalimpong land where a portion of the land was used by the government, the rest given back. They are supposed to come out with instructions. Then they say they'll file an affidavit in opposition. 2 weeks time was given. That has expired. Mr.
You
Supa.
have not yet filed. You have not yet filed.
I think a belated affidavit, Lord, was served on us. Now,
It has been served upon you.
Yes, yes.
You used a reply.
No, I will argue.
Where is Mr. Subba?
He is on the way, my lord. এটা তো এক্সট্রা আছে না
এটা আমাদের কপি আপনার কপি
ঠিক আছে হ্যাঁ আসছে
Who is for the state? You are for the state.
My lord, copy not even sub.
But there are 4 respondents.
Not given copy?
Yes, yes. Stay application copy you have. Stay application copy you have. No, opposition of the GTA, my lord.
Opposition what you require?
State says it is the GTA's land, my lord. Initially, when the writ petition was filed, kindly come, my lord, to the writ petition. It's annexed at page 38 onwards of your lordship's brief. Please come, my lord.
It is your GTA land.
It is land belonging to me. The GTA, the Darjeeling Gorkha Hill Council, as it then was, now substituted by the Gorkha Land Territorial Administration, barged into my land and took over possession without any prior acquisition, without any notice whatsoever. Thereafter, my lord, I filed the writ petition asking for recovery of the land. In the meantime, the matter remained pending, my lord. It was a writ petition of the year 2011. The matter remained pending for quite a while. Ultimately, the state and the GTA arrived. GTA was substituted in place and stead of the Darjeeling Gorkha Hill Council. The state said that GTA is the be-all and end-all of decision-making as far as this is concerned because it is land belonging to their territorial administration. The Honorable Judge posed a question as to whether there was any acquisition on behalf of the state because GTA can't acquire. GTA can, or Darjeeling Gorkha Hill Council could not have acquired. State had to acquire.
Version is necessary, no?
State is saying that they have not acquired. State has completely said that they are not necessary. Mr. Sen came on the earlier occasion, also before a coordinate bench, saying that it is not our acquisition. We have not acquired. GTA will answer. GTA comes before the Honorable Single Judge. Honorable Single Judge says, I will give you 3 options. You are in possession of the land. You have used a portion, small portion of the land according to you, and the remaining according to you is fallow. Therefore, you do one of the 3 things. 1, you have stepped into possession without acquisition, give back the entire land. 2,
If you want to take over the entire land, you take over the entire land and by a process of acquisition. In the meantime, the rental compensation up to today you pay. Third, if you think that that 0. A very small portion of the land which they had used in they alleged to have used in the frontage of the property, if you think that
They acquire under which provision?
they will tell the state to acquire, they can't do anything. Here is the entire trouble, my lord. Now they say the third thing is
That is an impossible condition then.
that's the first condition. Second condition, give back was my prayer.
So now what was the third
condition was you have used 0.80 acres or something out of the macro land which is in the frontage. You say that you need it and you have used it. We are disputing that they have used it, but they say that we will use it. So the honorable judge says, out of these three, if you choose one, that is, you make a passage, you make a road connecting that land with the other part of the land, because this is hilly land. So this land is not on a straight plane. After they use up the frontage, thereafter access will be impossible for me unless it is connected by a proper passage. Honorable First Court says, please construct a road connecting the balance part of the land to the motorable access way. Thereafter, that portion you acquire, have it acquired. Remaining portion, give it back. This was the option. They were given the option. I was a bystander.
How they will acquire?
They will get it acquired or they will buy it out from me. Now they said
it still remains to be state's land, na?
It still remains to be state's land. No, my land. It's my land. It's my land.
So if you say that it is your land, question of acquirement by the state does not occasion. That will be your argument because they have not done so.
They have not done so up to now.
When they have not done so, frontage area, how they can take steps for acquisition?
They cannot. According to me, that is why this is my appeal.
Now, what is their stand? What
They are
do
saying,
say?
pursuant to the honorable single judge's option, we have exercised option number 3, that is part construction, and we have exercised, we are putting up tenders, we are calling people, we are doing this, we are doing that, we will make that passage. 1.5 to 2 years have passed. That road has not seen the light of day.
So you waited for 20 years. 2011, the matter was filed.
Yes, my lord.
So give them some time, they will do it.
But
If
they are not
doing
doing it. But the information inside is, and that is a super way.
No, Mr. Banerjee, up to this stage, can we say it is admitted? They are opting for the third option.
They are opting. I am saying, yes.
We have now, if they opt for the third option, they have to make a road, 2-year road. You are saying that though they are saying so, they have not taken any steps.
My grievance in the appeal is different. I am saying this.
No, are you not agreeing to this third option?
I have
not
never
agreed.
No. I say, please give me back my land.
No, when
How can that be, Lordship?
We didn't follow your argument. First, you were
That
not
pond
saying,
is there, Lordship.
you said that they are
Tank is there.
Options not given to. Please, just a second, sir. The 3 options were not given to
Mr.
me.
Banerjee, make up your mind.
No, I made it up.
If you say that the third option, you are also that no
The third-
options you are agreeing to, then the appeal has to be hard. File your paperwork.
State did not, my lord.
No, forget about state.
My
If
lord,
you are
the
not,
honorable-
if you, I understood, maybe I don't know about my brother. First, I understood that they were not agreeing to first, they are not agreeing to second, but they are agreeing to third, but they are not completing the work.
That they
is
have
the
not.
grievance.
This is the ground reality.
That is the, if that is the issue, we can deal with him appropriately. But if you say today that no, you don't have to deal, you hear the appeal and I am not agreeable to any of the option, we will hear the appeal.
Now, my lord, my instructions are that I
Actual
want my land.
choice is yours, Mr.
Instructions,
Banerjee.
my lord, are that I want my land back.
Huh?
Want my entire land back.
So very
Today, I'll tell you, lordship.
Then you file your paper books, we'll hear
That
the
is
appeal.
impossible.
Today, I'll tell you, lordship, why. Today, I am out of land. I am the title holder. I am out of land. No proceeding for acquisition has ever been done in respect of any part ever till today. They are perching on a portion of my land without authority of law. They are sitting there and to facilitate their staying back on that forcibly possessed portion by making another road, according to me, is something which is contrary to law. If they acquire, let them acquire. If they don't acquire, let them give back.
On that day,
Lordship, the tank, water tank.
It is
That the
already
land-
there, your lordship.
They are not in a position to return the land. They have already utilized in a.
Lordship will kindly come to
If they have,
page.
if they have done so today, I kindly take this. If they have constructed a tank,
They paid some rent.
no, that is rent compensation for illegally barging into my premises. That is rent compensation for that period. That is not acquisition. Acquisition compensation is 2013 Act. They were required to take steps in order to give a section 4 followed by a section 6, 5A 6 and thereafter award. They have ought to have taken possession earlier, but here the cart has come before the horse. But that cannot do away with the proceedings of acquisition. By barging in and paying rental compensation for the period of wrongful occupation, they can't claim title over the land. So I am saying forget about 0.8 acres out of the total land area. No part or proportion of the land can be retained by them unless it is acquired. They say we won't acquire because we can't acquire. State says it is their subject. They will have to acquire. They have a pecuniary limit for acquiring, which is 25 lakhs. Beyond that, they have to ask the finance department of the state. State says there can be no question of R being asked. I am in the lurch. I am saying only a simple thing, my lord. If they can today, even when your lordship hears the appeal, finally it can even be today. I'll tell your lordship why. Everyone is out with all the documents. There is nothing suggesting that there has ever been any acquisition in respect of that portion. Admittedly, they are in wrongful occupation of the entire portion. Learned judge has told them to return the remaining portion. It is full of encroachers and their own persons. It is physically unreturnable. Second is one part they say that they have acquired, that is the prime part of the land. Acquired means they are in forcible possession, they have made a tank. I am saying for the tank part or the remaining part or any portion thereof, they don't have any right to remain in possession. Let them give back or let them acquire in their entirety. But saying that a road will be made to facilitate their trespass, Lord, according to me, this option was not given to me. All the orders are there. This is an option given to them. If their option was suitable for me, I would have agreed. I have never agreed. On the last day before the Honorable Single Judge, the Honorable Single Judge said, option 3 is being exercised by them. I will tell them to make the road within 9 months and I'll dispose of the writ petition. My contention was I am not agreeable to have option 1, 2, 3. It's either 1 or 2. That is, either take the land, give me compensation after acquiring in accordance with law, or give back the land. And the rental compensation of 24 lakhs, which they have paid in the meantime, is for their holding that land in possession without authority of law. This is not equable with the compensation for acquisition. This is a different species. That's a different species. There, 24 lakhs I have got, which according to me, my instructions is the pittance for the total amount that I will get under the 2013 Act if they acquire. Now, if they say we don't have the money to acquire, let them vacate. How can a road come up, my lord? It was prime land. It was my land. I was thinking of developing that land, my lord, and putting up constructions. At this stage, they barge in. Now, my lord, between the state and the GTA, there is a ping pong match. One day state appears, GTA doesn't appear. The other day GTA appears, state doesn't appear. State says we have nothing to do with this GTA land. GTA says we can't acquire, state has to acquire. Pecuniary limit is 25 lakhs for GTA. Your lordship will see a series of orders, including the last order. Argument of Mr. Subba was, why did Mr. Banerjee's client countenance?
First of all, Mr. Banerjee, you did not appear before the writ court. We don't understand
Yes,
the
I appeared
tenor.
for
You appeared.
Yes, yes.
Your tenor of argument, you are so vociferous that the entire thing has to be done. This is never reflected anywhere in the order. Why did the court call for option? Unless you tilt your head, why the court will call for action?
The court called for option in order to make them do something.
I don't understand.
My lord, kindly see.
There must
I
be-
have not
you are
invited.
placing the case in a different.
My lord, I am not inviting it. But with great respect,
All right,
my lord,
all right.
kindly-
Yes, Mr. Subba, what
Yes,
is
your
your
lordship.
contention? Why was the option asked
Lordship, the first of all, lordship, let me tell the facts, your lordship. Facts of the case is like this, your lordship. My learned friends' clients, they had 4 point something, your lordship, acres of land in Kalimpong, your lordship. In 2003, it was felt that Kalimpong was suffering from water crisis, your lordship. So for the public purpose, for the making of a tank, your lordship, water reservoir, some land was taken, your lordship, from his own
by
affidavit
Diden Hill Council?
Deed and Hill Council, Lordship. That time it was DGSC, Lordship.
That
Darjeeling
was,
Gorkha Hill
some
Council.
portion was taken from whom? They were in possession.
They were in possession, but it was taken at that time, Your Lordship. Somehow it was, we don't know at that time, Your Lordship.
How much portion was taken?
It was only 1.40, according to their own writ application, 1.40 acres, Your Lordship.
1.40
40 only, Your Lordship. Lordship will kindly
out
see
of 4
page
acres.
52. Page 52.
We will come to it. Let us know the story.
Wait, Your Lordship.
Total land was about 4 point something acres.
Yes, Your Lordship.
Out of which, to construct a tank, you took from them a portion of 1.4 acres.
1.4, around 1.4 acres.
Around, for which you paid rent compensation.
Yes, Your Lordship. And one tank was
the rent compensation which you paid
for the whole.
For
the whole area. Yes, Your Lordship. For the whole area. For 4.5, Your Lordship.
About 22 lakhs you paid.
Yes, Your Lordship.
That was in which year?
That was, Lordship, in the year we paid
from the year 2003 onwards.
So they were not, they didn't pay from 2003 onwards. They paid under orders of the Honorable Single Judge in sometime in 2023 or 24.
23, Your Lordship, I think.
Very good. Then what happened?
23. Lordship, already the tank is there, Your Lordship. Tank is there, which cannot be dismantled, Your Lordship. It will be used for this thing. So their contention was that, Your Lordship, they cannot go behind their 4 acres of land. So that is why these options came, Your Lordship. They said
So
that
they are in possession over the entirety,
yes, Your Lordship, they
except
are
1.4 acres.
So we said at that time, Lordship, that we need only 0.80. In fact, we don't need this thing, 1.40 also. So we gave back 0.60. We gave back, Your Lordship.
When
we
did
released.
you give it back? When did you give it back?
No, Lordship, it was not. We said that we need only 0.80 because court said what amount of land do you require, Your Lordship.
So now what is your stand? What you have not
Lordship,
even constructed
Lordship, after the order of the trial court, Your Lordship, after the court of the
No, Mr. Subba, you are saying that they are in possession of the entirety of it, 7 except 1.4. He is disputing that.
That is
He's
that,
saying
that,
you
that is
are
the
in
fact.
possession.
That is the fact. That is their own writ petition, Your Lordship. Lordship will kindly see the writ petition. That is why I was pointing out, Your Lordship.
Yes.
Lordship will kindly come to page 52, where they have annexed the writ petition, Your Lordship.
Page 52.
52, Your Lordship, of their application.
Yes.
That a portion of the said land which was lying vacant, suddenly encroached upon and forcibly occupied by the Kalimpong Engineering Department Division in February 2003, without any intimation to or prior notice to the petitioner. The fencing around the whole of the land was also removed. A lake or reservoir was constructed on the part of the said encroached land covering about 1.40 acres of the petitioner's land. So we were never in occupation of the whole land, Your Lordship. In fact, they chose not to go there. Lordship,
Now,
kindly see
no,
this.
no, let us understand. Now, Mr. Subba, so far as the third option goes,
yes, Your Lordship,
you have to construct a road so that they can get access to the main road.
We have volunteered, Lordship. We have volunteered to make the access road, Your Lordship.
So what is the status of such volunteer?
Lordship, we have already given the work order also, Your Lordship. Tender notice was given, everything was given, Your Lordship. But however, they have approached, I have heard they have approached the contractor, Lordship, not to make it because this appeal is pending here, Lordship.
What is he saying, madam? This is completely, let him
Off
not
the
say
record.
things which are not, this is not on record. They filed an affidavit. This is not on record. This is not done. Why is he making
Where
cutting
is your work
But it is,
order?
what is
Where is your work order?
work order, Lordship? Work order is work order is tender notice, page 76.
If you today say that none of the options you are agreeing to,
I'm agreeing to one option, option 1 or option 2. Option 1 or option 2. That is,
no, the third
you
option
take-
has been proceeded.
I'll tell you, Lordship, why. There,
Against that, they haven't come for the appeal, Your Lordship.
I'll tell you, Lordship.
No,
Yes.
one thing, Mr. If you say that they shall be bound to acquire the entire land, it would be a financial burden for them. Out of 4 acre or 4.5 acre, they have only utilized 1.40 acre. If any
0.80, Lordship.
If
0.80.
any road, motorable road is made, or the rest part can be made usable by you. They would be made in such a way that you can use and utilize the same. And if the 1.4 acre there are division, you take a proper step so that it can be acquired following the procedure. That would be the possible settlement. If you say that no, everything will be frustrated, that should not be proper.
That cannot ultimately settle that.
I mean, officer of court, I cannot make unreasonable.
No,
submission.
you consult with your client if they are in possession of the remaining part which you are disputing. Which you are disputing.
I have
He
pictures
says
to show.
that the remaining portion is of. If you are not at all in possession, then question of any settlement does not occasion. We will hear the appeal, we'll finish it. But if you think, just we are having an impression that when the trial court has given 3 options, when in presence of a party, the other party has proceeded on the 3rd option.
Yes.
However, there are disputes pending. So if you ascertain, because what is the use of keeping the matter in the doldrums? Your portion of possession as regards the remaining is undisturbed. Your problem on the throat is this front portion which is if it is a thing which has been done in public interest and which may jeopardize the lives and living of the particular persons, then court will also be hesitant at the first instance to go into. So I think you
view
should
would be in the event
now,
they give us that.
in the event this 3rd option is acceptable to you, then we can ensure that whether the work has to be completed within the time or not. We will keep the matter pending, ensure that that is given. After you get that access, then we will go with the proposal which my brother is suggesting. That you acquire this land in the usual manner and then pay the money which is.
I'm grateful to what this would have been. This is the practical solution to the problem. There's only one small rider which I would want to attach for your lordship's consideration. The remaining part of 4 acres of land, I have lost my value because the frontage has gone. That will be taken care in the compensation.
It's compensation, whether diminished.
Yes, diminished value, etc. So that's neither here nor there.
Yes.
My practical problem is when I had a fenced land of 4.80, they took the frontal part by breaking open the entire fence. 4.80, they have constructed a tank. They have given rental compensation for the entire land for this period, which means they are admitting that I am in possession. They were in possession of the entire land. Today, when the learned judge, my lord, has directed the return of the balance land, they are not in a position to return the balance land to me. That is the ground reality. Mr. Subba will check with his client.
No, your lordship, it is not true
Mr.
at
Subba
all.
will
At all.
kindly
They
check.
are not taking that land, your lordship.
Mr. Subba will check.
Nobody is there.
No,
Which land?
The rest of the land, your lordship.
4 acres. They are
It was
not in
their
a
case.
position. I am told there are encroachers. There are persons who have been put on possession by them.
Because they didn't take the position, your lordship.
Because
They left the land.
So they will.
You said you are in possession.
Please. 4.80, I was in possession. How does one retain possession of a land in the hills? Mr. Subba, just a second. 4.80, how does one retain possession? By constructing a fence around the land. That was there. It's admitted. They also say it's admitted. What does the Darjeeling Hill Council do? Comes up, uses authority beyond the authority of law, barges into my land, demolishes the entire fencing, gets into possession. Thereafter, Darjeeling Gorkha Hill Council keeps it in limbo. I am not allowed to go to my land. If I go to my land, there is threat of life to my directors. In the meantime, sanity prevails in 2011. Darjeeling Gorkha Hill Council is dissolved and succeeded by the Gorkhaland Territorial Administration. In terms of a treaty between the state government and the Gorkhaland Territorial Administration, that will be their portion. They will.
So, in short,
in 2011, my lord.
In short, that some outsider has now entered into the land and they are possessing.
If they can evacuate them, remove them, and give me back possession of 4 acres, then this will be a profitable thing, my lord. What has fallen from my lord justice?
So you say whether you will be able to return the rest part of the land as it was when
you enter.
As we haven't taken, your lordship, we haven't taken. That is the whole thing, your lordship. It is being imposed on us.
Kindly see.
It is being imposed on us. From their own affidavit, from their own statement, your lordship.
No, my lord, they have not taken only 1.4. They say that on 1.4 they will make the tank.
Their own writ petition, your lordship.
1.4 না বলছে আমার ট্যাঙ্কটা আর এনক্রোচার ঢুকেছে বাট তুই কেন আর তুমি আমরা রিট কোর্টে অ্যাপিল করছি কি করে মানে এনক্রোচার
In the learned single judge directed them to return. Who can be directed to return? He who is in possession can return. They are not in appeal.
Where is that?
Please come below. To the order impugned, it's in the memorandum. Please give me a moment.
That was the second option to return.
No, third option, return the balance. Please come to me, Lord.
Second option.
Yes.
Internal page.
First option is, yes, internal page. My lord, kindly see internal page 3.
No, first come to page 2.
Yes, the
what
3
were the options?
One is retain or acquire entirety.
Second was to
is
enter.
return entirety. Third is make alternative provision which would give access from the well-constructed PWD road to the 4 acres of land of the petitioner, if necessary, by constructing alternative road, giving passage to vehicles, and return that land, because that direction is there. To buttress my submission, may I take your lordship into internal page 4? Kindly come to internal page 4.
I don't think that line is there.
Just a second, brother. You can't eat the cake and have it too. If you say you will give back fairly. Kindly see internal page 4. However, due to somewhere down the middle of the first paragraph, however, due to exercise of third option of 4.00 acres of land stands released from the possession of the respondent authorities in favor of the petitioner, and petitioner shall be free to enjoy the ownership and possession of the said 40 acres. What does that mean? 3 things. 1, they are in possession of 4. They will give back the 4. I am entitled to enjoy. That has been secured by the learned judge. Now they say that portion is now encroached upon by persons whom they have put in possession, and they now are denying that they were in possession at all. Is there a cross appeal from here? I'm asking myself, have they challenged this finding of the learned single judge? Before them, before the learned single judge, there were 5 affidavits filed by them. In every affidavit, it is stated that they are in possession of the entirety.
No, your lordship. In fact, we had gone for appeal, your lordship.
You had gone for appeal because you didn't want to pay 22 lakhs
No,
as
your lordship, it's not
compensation,
that. Yes.
rental compensation. That was dismissed by a
Because
court.
there our ground was, your lordship, that the whole land was not in our possession at
land
any
was-
time, your lordship.
Where is that appeal? Order?
Lordship, kindly come to this. I have annexed the order, lordship. Order of the appeal court. Order of the appeal court is
অনেক দিনের ঝামেলা।
There are a series of orders.
Page 4 এর first paragraph। সেজন্য বলে দিল ওই পোর্শনটা ছেড়ে দাও। Which page?
lordship, I'm coming to lordship, kindly give this. নিচে দেখো তো, নিচে ওটা দেখো তো, নিচে
In compensation against it.
Please see page 170, the Honorable Single Judge records the order of the appeal court, or records the fact that the appeal court has not interfered.
lordship, page 6.
No, no, 167 brother. 167.
167.
167.
I'm grateful.
Thank you.
167. That was yes, your lordship. 167. In your lordship.
Rate of compensation was challenged. Rate of rent compensation, not compensation for acquisition.
Now, your lordship will kindly come to page 168. 1, 2, 3, 4.
নিয়ে যাবেন তো আমার নিয়ে যাবেন তো চলো না।
That is only a disputed. He says 168 first para last 2 lines. According to the writ petitioner, a reservoir has been constructed on 0.8 acre of land and the remaining 4 acres has been left inaccessible to the writ petitioner. To that you denied that contention, and as regards the rent compensation, court passed the order.
His challenge was that there should not be rent compensation.
Kindly come to this my submission, which was recorded there, lordship. Page 168.
Yes.
Page 168, 1 to 4, para 4. In the appeal, Mr. Subha, learned advocate appearing on behalf of the appellant says that his client was never in possession of 4.80 acres of the land. In fact, only 0.8 of the land was in his client's possession.
Now, kindly see the Honorable Division Bench's finding. It appears that for the first time, the stand is being taken by the appellant before us. It also appears that this point was never urged before the learned single judge. We are not inclined to entertain this appeal. Dismissed. And he is not aggrieved. Mr. Supa's client is not aggrieved by the order of the learned single judge, which says that the possession of 4 acres should be given to me. I should have ownership and possession. When would the court pass such an order? When it's a finding of the court, by very necessary implication that they are in possession. Did they prefer an appeal against that order, my lord? At that part of the order, they have not. Now, my lord, before every honorable appeal court, they will come and say, we only took over 0.8. I am saying they demolished the entire fencing, got into possession of the entire land. Hoodlums were in possession of the Darjeeling Gorkha Hill Council. I was not allowed to go within 1 kilometer for fear of being shot dead. The situation improved only after the GTA came in. Some sanity was restored. I said, please give me back my land. Now they have come up with proposal 3. They can't give back 4 acres to me. They have not yet made the road. My lord, option 3 has been reduced to a nullity by their own inaction. And they are saying, my lord,
Lordship, in
contractor,
any-
they are saying contractor, my lord, 25 lakhs is the work order. Their pecuniary limit is 25 lakhs. Their work order is more than 25 lakhs.
So go and fight before the trial judge. We will set aside
Yes,
this order, remand the matter to the learned single judge for
Lordship,
appraisal.
again, Pandora's box will open, your
Yes,
Lordship.
let them go, let them proceed how they can get possession.
My lord, otherwise, I am saying only this,
Because your
my lord,
lordship-
my lord. My lord,
We were giving you an opportunity to solve the problem.
If they
None of
can't
you are
give me-
ready.
No, my lord, they can't.
That was given. That was given in the lower court. Enough orders were
Question
given,
of
your Lordship.
possession, encroachment, everything will be left open. The situation as it is today will continue. Go on fighting. Let them go on fighting.
No, my lord, otherwise let them give me back my 4 acres.
Sorry.
We have given
My
back,
lord,
your Lordship.
let them
We will
give me
say
back.
we will allow your appeal. We will set aside the
Lordship,
options
Lordship,
and
Lordship will kindly see the work
and
order,
we will
Lordship.
remand it back to the trial judge
Lordship
to
will
hear
kindly-
the writ petition afresh, together with the observation of the appeal court that this
They're
point will
only-
be agitated.
Lordship, there are only grievances regarding the compensation, your Lordship. Lordship, their grievances.
Contention is that my lord, against the order dated 21st of November 2022 at page number 160, and my lord, the subsequent order based on this order, that is my lord, the subsequent order at page 163, that is 8 December 2022. Now my lord, so far the order dated 21st of November 2022, whereby, my lord, the option that was given by the court and accepted by the parties with regard to that order.
That we do not know. How where it is accepted. It is not said that they have accepted the option.
Each order was passed in their presence.
Maybe, but
Yes. Then, my lord,
the
kindly-
council is saying we have not accepted.
Then,
Land
my lord,
is mine, choice is mine.
kindly consider then the second order. The first order, that is, my lord, 21st of November 2022 order merged with the subsequent order of 8 December 2022. So kindly have a look. When the offer,
21st November is not even an order because court decided nothing.
when
Court
the
said,
order,
let it capture. We,
court said that one of the option accepted by one of the parties, because the offer was, my lord, to the parties to the litigation.
Not the parties, only to
Kindly
GT.
consider.
Only to
They, kindly consider. Because the consequence of the offer, it was in their knowledge that if the, my lord, the second offer or third offer accepted, then what would happen? That, my lord, it was, my lord, that, my lord, anybody could have imagined that consequence of the acceptance of the one of the offer by the, my lord, GTA, then what would be the consequence? Now accepted that consequence, the future consequence, and the subsequent order based on that the GTA accepted one of the option out of
we
three.
cannot insist, Mr. Sen. When he says that I am not accepting, I didn't say
Then no
that.
appeal paper against this.
No,
Kindly
there is no
consider.
acceptance.
They have preferred appeal.
Appeal against the
Against
final
this
order.
order, no appeal paper.
This order, what was done? Three options were
Three option,
were called for.
three option, first, second, third. Either the entire return or keep a piece of the land or acquire the entire.
Mr. Banerjee says they are not agreeable to either of the options.
Then the appeal.
I want my land back. This
Then
is his
appeal could have been prepared against that. Lordship, kindly
Why?
consider.
Option,
Because that was an
there
order.
was no direction that there is no observation. They have accepted this option.
They have not accepted, but they
Achha, Mr. Sen,
accepted
if
by
they
their.
do not want to solve their problem, what you are going to do? What you will do? They are now saying, I am not, what he has said is, I am not accepting any of the option. The entire land, I am the owner. Under the garb of construction of a particular water tank on 0.8 acres, they have either inducted persons taken over possession, barged into my land. So we will set aside the order of the single judge and we will remand the matter to hear the issue as regards acquisition of the entire.
But kindly consider one thing. The final order, kindly consider one thing. The order
Our issue
impugn.
consideration, we for half an hour, we insisted that some sort of settlement.
They can't give it back to us
The
today.
final order,
Mr.
that
Subba
is
can't give back the 4 acres to us today. Mr. Subba's clients at ground zero will not give it
He
back.
will leave
Then,
you
my lord,
as you are there at the time of filing.
if they fail to give position, then my lord, they can file a contempt proceeding.
Lord,
I am not-
why- and
but the question is, Lordship, kindly consider.
great respect.
Final order or impugn order is not an independent order. My lord, kindly consider. The final order or the impugn order passed on the basis of the earlier order passed by the court.
It is my land, my lord. It is my land. The option should be mine. GTA takes and selects an option. I am saying from the very beginning.
Passed on the basis of the earlier orders
I have
passed
not
by
put
the
down
court.
I have not put
And
down
my
my
lord,
prayer.
on the basis of submissions by the councils of the
Lordship sends
party.
me back to the learned single judge, Lord, to the position that I
They
was.
could have said
I
that
either win or I lose.
that so far that order with regard to that, my lord, that giving option to the parties, my lord, they could have said that no, we do not agree with this. Then the matter would have, my lord, the ended therein, and the court could have proceeded with the matter in other way. The court may not go in that way. What my learned friend now is saying that on behalf of the appellant, he could have said so at that point of time. It's more or less, my lord, it's a case of acquiescence.
Acquiescence to
You
an
agreed
interim
to
order.
that.
Acquiescence to an interim order where an option is not given
It was
to me.
not an interim order.
Lord, it's my land.
It was on the way of proceeding the matter.
Unfortunately for
And
Mr. Sen's client, the land is mine. So
nobody
all
is
options are available to
denying.
me.
Nobody is
A
denying.
trespasser can't be given option to eat away my title. I have to be given an option whether I succumb to him or not. I am not succumbing to him.
But what,
I have never said in any of the orders before the court below that I am succumbing to him.
what prevented the appellant hearing to raise their objection at that point of time?
I was not called upon.
It was in his presence.
Kindly, no, I've given the entire set of orders. Please peruse it, my lord, and at my peril I am submitting.
Preceded, I find that there were inspection reports.
Inspection
for them to ascertain how much cost is required for
They
the
were there,
work.
Lordship.
So question
In all
is,
the inspections, they were there, Lordship.
So the final order based on the earlier order, series
kindly
of
send
orders.
it back to the learned single judge.
Series of orders.
Kindly let us go back to the learned single judge. Either they acquire the whole or they give me back the whole. These 4 acres encroached points.
But that issue is no more.
And I am astonished that the state, without carrying an appeal from the order, is coming and arguing for the GTA. Yes. And the GTA being in ground zero is keeping glibly quiet.
I'm not quiet.
Okay, Darjeeling Bayaji hai.
কালিম্পং বলেছে এটা ভালো ফগ হয় ওই কিছুটা ফগই এখানে এনেছে
So these facts has are brought to the notice of the learned single bench that now the rest portion has been encroached by the outsider.
Who had to bring it to the notice? The person who is giving back? Person who is giving back? Because the learned single judge has said, 4 acres is with you.
The matter back to the.
Please send it back. Please send it back. Because, my lord, they have taken my land. I am out of possession. I am out. My title still remains in me. It is a blank title, hollow title. They were told to give me back 4 acres. They are not in a position to give back. They were told to make road. They have a pecuniary limit of 25 lakhs. Their contractors' value of contract is more than 25 lakhs. So this is a red herring. It is being shown to the single judge and before this honorable court for the last 1.5 years.
Come to the last portion of the order.
Yes, please, my lord.
This rental compensation issue has been left open by the judge saying
That's
you may
rental.
go.
That's rental.
How you are agreed by which portion of the order?
The portion by which option C was implemented. The rental compensation portion is a pittance. My lord, it's for the purpose of unlawful possession. It's rental damages.
This order has said that they will make the road within any particular time. Anything
9 months, yes.
Where?
Please come. Internal page 3, second last paragraph. Having considered this affidavit and statements made in paragraph 5, this affidavit is my learned friend Mr. Subba's client's affidavit. The writ petition stands disposed of by directing concerned authorities of Gorkhaland Territorial Administration as well as state respondents to complete the construction of alternative vehicular approach road.
রোড বানানোটাই তো হবে না বুঝতে পারছি
It's an unworkable order, my lord. I am left in the lurch.
স্ট্যান্ড রিলিজ তারপরে এখন তো রিলিজ হয়ে গেল আগে তাহলে রেসপন্ডেন্টের পজিশন থেকে এটা
গেছে তো
এরপরে হিয়ারিং তো ওইখানে
কোথায় হবে
ওই দার্জিলিংয়েই হয়
দার্জিলিং অত ফগ হয় না লিটনে ফগ হয় এই ম্যাটারে বাসায়
6 মাসে একবার শুধু ফগ নিয়ে আসছে
কিন্তু এক্সারসাইজ অফ থার্ড অফ
আর ওকে দেখাও যায় না ফগেতে লুকিয়ে পড়ে
stands release
ওকে
from
পাওয়া
the
যায় না
position of the respondent in favor of the reported mandate.
কোর্টের ম্যান্ডেট আমরা অন্ডার টু রিলিজ হয়ে গেছে
But he is telling me
এই ফ্যাক্টটা হ্যাজ নট বিন ব্রট টু দ্য নোটিস অফ দ্য
টাকা পয়সা দেওয়া হয়ে গেছে ওয়ার্ক অর্ডার অনুযায়ী কিছু
কিচ্ছু টাকা পয়সা দেন 25 লক্ষ টাকা ওদের লিমিট কি করে 25 লক্ষের বেশি টাকা দেবেন আপনি কি বলছেন সুব্বা সাহেব
50 লাখ অব্দি না
রেকর্ড কল ফর কোন দেবেন কিচ্ছু হয়নি ওরকম 3খানা টেন্ডার নোটিশ রোজ ওরা দিচ্ছে কিচ্ছু হয়নি
2882 excess. 2882 in excess.
মানে ওটা কি মানে এটসেট্রা করে হবে ধরুন আপনার ইনকাম ট্যাক্স স্ল্যাবে আপনি ওইটুকুই শুধু থার্ড স্ল্যাবে পড়ছেন তা ওটা না দিলেও চলবে নাকি
কত হচ্ছে দেখা কোটি
কারণ রোড কনস্ট্রাক্ট করে দিলে রোড কনস্ট্রাকশনটা করা কি উচিত হবে
Roshi, the work order has been given on 22nd of November.
Your paperbooks will hear the appeal.
Very well, Lordship.
The present appeal has been preferred challenging Ask your junior to mention. Ask him to mention, we will consider.